Any mention?
Yes.
Please, Your Lordship. Item number 33, Your Lordship, if it matter, come up next week. 33.
30?
3.
33. Short matter, long matter?
Short matter, Your Lordship.
Short matter, then why Johnny?
Next, because some research, I need to do some research. Some research, Your Lordship.
No objection, Your
2
Lordship.
weeks, yes.
Obliged, Your Lordship.
Much obliged.
Do complete research. Yes.
Please, Your Lordship. I beg to mention item number 30, Your Lordship.
Number?
30. I've informed the other side, Your Lordship.
Samsun Nihar. Who's other side? Sheikh?
No, Lordship.
Karmi?
Yes.
Yeah. 2 weeks, right?
Much obliged, Lordship.
Yes.
May I please, Lordship? Lordship, I beg to mention item number 34, Lordship.
30?
34, Lordship.
Some correction we have met.
By whom?
By the petitioner, Lordship.
What correction?
Only that petitioner association and petitioner only association deleted.
You're asking adjournment or you're asking who?
I'm pleading for German, Lordship.
Oh, EG is not here. 3 weeks, yes.
Lordship.
Yes.
Lordship, Lodge.
As EG is out of the country. Correct? Yes. Yes.
I do Lodge.
Please, Your Lordship. Your Lordship, I beg to mention item number 25, Your Lordship. I humbly pray, Your Lordship, that the matter may be listed after 2 weeks, Your Lordship.
No objection, Lordship.
No urgency.
No urgency, Lordship.
2 weeks, okay.
Much obliged, Lordship.
Some accommodation for item number 29, Your Lordship. Only 1 week time, Your Lordship.
But who's that on the other side?
Petitioner, I have informed, Your Lordship. Only 1 week time.
MS Wani, no objection.
No objection.
Any urgency? No urgency. 2 weeks, okay.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 32, Your Lordship. I kindly pray for 2 weeks' time.
32?
Yes, Your Lordship.
Mutishak. This
Yes.
is on behalf of Yubin.
Yes, Your Lordship.
Who's for the petitioner?
I've not seen them, Your Lordship.
Yes?
I haven't seen them, Your Lordship.
You pay the salary?
Your Lordship, we are yet to receive instruction, Your Lordship.
Okay. 2 weeks, yes.
Deeply obliged, Your Lordship.
Yes.
Supplementary list, item number 1.
Submit item 1. Yes, you want to mention, Mr. Chadda?
Yes, I
What do you want to mention? What item?
No, it's not mentioning.
Yes, what?
Lordship, it's just, I think, confusion, Lordship. Supplementary list, item number 1 here.
Somebody asked him some course to do Rahman?
It's a mistake.
Yes. What is this, Mr. Khan? Long last week you are doing a civil matter?
Yes.
I mean civil revision, not a writ.
Lordship.
Yes.
Lordship, issue is very limited. The opposite party's plaintiff had filed a title suit TS 9 of 2019.
Okay.
Again, and then we have filed a written statement, and the matter was posted for suggested issues. Issues was framed, and then we filed an application under Order 14 Rule 2, where among different issues, if the court finds important issue of law is involved, then court has to decide that.
Yes.
So that is
preliminary issue.
Preliminary issue.
Then what happened?
No, it's an admitted fact, Your Lordship, that the cause of action arose. As per para 41 of the plaint, the cause of action arose of the plaintiff way back in 2000. Plaint is at. Lordship, we just come to page 25.
Yes. Which para?
Para 41, Lordship. First, Lordship, we come to para 40.
Okay.
The plaintiff begs to state that the instant suit is within the period of limitation and the entire subject matter is sub judice, and the suit plot of land under under custodial leges since the year 2001 is to till date under the miscase number so and so.
Okay.
So, they please, Your Lordship, some matter of 145 is
140 matters
proceeding.
pending.
Next paragraph is important, Your Lordship. That cause of action of the suit arose with the territorial jurisdiction of this learned court in the year 2001.
Okay.
With the miscase number so and so 145 was registered irrespective of the suit plot of land, and the suit plot of land was kept under attachment on 13/11/2001. The cause of action again arose on the year 2009 to 2010.
So your main grounds on limitation 12 years, something like that.
Lordship, my ground is 64-65 limitation. We file an application under 14(2), and Your Lordship, my Lordship will come to my application, which is at page 136.
From which code is 227?
Your Lordship is from the Assistant Deputy Commissioner Fulbari. Yes, Lordship. Fulbari Division.
Page 136.
136, Lordship.
Okay.
Para 3, Your Lordship.
Okay. Now what happened after
Now,
that?
Lordship will see reply to para 3, which is again at next, which is at page 1, para 7, Your Lordship. 140.
As such, it's not a starting point limitation is in suit.
Para 7, Your Lordship, of the reply that they have filed.
Yes.
It's very important, Your Lordship. I'll just come to it. Why the last paragraph is very important. Last part, Your Lordship. That the miscase number so and so was initiated on good faith, and the said proceedings continued and is pending till date of the institution of the instant suit. Lordship, this is the only stand that they have taken. Now, the requirement of law under 14, Your Lordship, if you want to get protection under 14, you have to show that you were proceeding with the cases in some forum which had no jurisdiction.
Yes.
Or it had wrong jurisdiction. Lordship, can I take Your Lordship to section 14 of the Limitation Act?
Bona fide belief, yes. We'll have to issue notice then.
Lordship,
Because it's,
only
on this point.
only Lordship. I'll just
Any
come.
other,
No, Lordship.
any other point which you've come before this court?
No, nothing much, Lordship.
That's the only-
The only limited issue, Lordship, if I come to the impugn order.
Yes.
Lordship, we have annexed in the first 3 pages.
Yes. 26/3004.
Lordship, yes.
Yes.
Lordship, last page but 1. If you just come to the
That will bear proof of case records.
yes, Lordship. If we come to that, Lordship, that it was admitted by both the parties. Lordship has got it.
Where reading from?
Lordship,
The
third page from the
order.
yes, Lordship, yes.
At least they should.
No, Lordship. I'm sorry. Page 146, Lordship. We'll just come to page 146.
They should at least.
Page 1. We have annexed the copy twice, Lordship. I'm sorry. Page 146, Lordship.
That what is admitted by both parties? Third para from the bottom.
No, the operative part, Lordship, will come at page 147, the last paragraph. 147, the last paragraph.
Yes.
That on the bare perusal of the case record, it appears that in the year 2001, when the case arose, the suit premise itself, by miscase number so and so, was kept under attachment order. White order it is so and so. Thereafter, 2001, the opposite party in the year 2002 filed an appeal before the court, additional district magistrate, white so and so. The appeal was dismissed on default of so and so. The opposite parties had later approached the Revenue Appellate Court. The matter was kept pending there for quite some time with no order passed disposing of so and so. Now, Lordship, this is relevant, Lordship. that without going into the merits of the instant suit was dismissed on default. The court is of the view, since the opposite party plaintiff had executed this civil proceeding in due diligence in the appropriate forum, having no jurisdiction. Lordship, it was not the case. This is the most relevant part, Lordship. Having no jurisdiction. It is not the case that they did not have a jurisdiction. They pursued it bona fide. The time taken to execute the civil proceeding shall be excluded from the final computation of limitation period by virtue of so and so. So on this ground itself.
But Mr. K. Khan is concert assisted by MS Raman also. How many respondents?
Only one sole respondent.
Issue notice sole respondent returnable within 3 weeks. Steps to be taken by registered AD within 3 days.
Lordship, only if the proceedings and the title suit may be kept in place.
Where you have a miscase?
No, Lordship. I didn't.
Have you prayer there?
There's a prayer, Lordship, but we didn't file a miscase because leave it to the discretion of the court.
The suit proceeding?
Court suit is proceeding, Lordship. Till the returnable date, Lordship.
Where is your prayer? For interim stay? Yes, it's provided till the next date. The further proceedings entitled suit number 9 of 2019 pending before the Court of the London Assistant Deputy Commissioner Circuit Court at Pulbari, West Garo Hills shall be kept in abeyance.
Obliged.
Item number 2.
May it please your Lordship. Lordship, in this matter, we have already preferred an appeal before the division bench, Lordship.
Matter, you got to stay.
Lordship, we have obtained stay also in this matter, Lordship.
Yes, Mr. Chadda, they obtained a stay against this court's order. Let's see. When was this?
We are not.
On 9th May, Lordship.
Yes. Okay.
Still, it is beyond the time prescribed time period as per section as per the Limitation Act, Article 117. The prescribed time period is 30 days to comply with the date from the date of the order or the decree.
Even then, Mr. Chadda, since the division bench has stated, so we'll keep this matter in abeyance only. MS A. Pradhan has informed the court that white order dated 9/5/2024, order dated of this court dated.
Lordship,
that means date
5/4/2020.
5/4/2020.
How many? Sorry. Wherein the direction has been issued for release of the gold bangle has been stayed. Such list is matter after when?
After
when the matter coming up again?
It's coming up on 9/7, Lordship. 9/7.
It's coming on 9/7.
Yes, Lordship.
Just the matter after 8 weeks. Yes.
Highly obliged.
Item number 3.
9/7 July.
This Lordship, this is regarding the non-releasing of family pension, because here petitioner is the wife of the deceased employee who was working as a UDA in the DC office, and he died in hardness. That is his employee on 2021 on 8. We have enclosed the death certificate also, but then his due retirement date was actually on 30 November 2024, but he died in hardness on 8/12/2021. But now it has been around 3 years since the wife of the petitioner.
What is the cause of delay according to them? What is the cause for the delay? You are regularized?
Yes, we are regularized. There is not, that is not disputing.
You are
I'm
the
regularized.
nominee? Or
Yes, I'm the nominee.
Some other wife lurking around?
No. I'm only single wife.
You're only single wife?
Yes. There is no other wife, my lord.
You sure?
Lordship.
You want one other pleading application tomorrow? His name Gormaswar Sama?
Lordship, I'm the wife of the Gormaswar Sama. Legally married. Married certificate also, Lordship, I have enclosed it. That is at page 13, Annex 2.
That's all?
Lordship.
Only 2 documents annex?
Because we don't have any other document, but here in that Annex 1, all the detail is mentioned, Lordship.
Yes, heard Mr. P.T. Sama issue notice. Mr. S.A. Sheikh is present, accept notice on behalf of
1, 2, and 3.
1, 2, and 3, and MSEB Persa on behalf of report number 4. This after 4 weeks for instructions. I agree with this.
Lordship.
Item number 4.
Item number.
This also pension.
This also, because here also I'm the driver. I'm the driver as a regular employee, working as in the PHC. I have retired on the 28 February 2023. Lordship.
Retired on?
28 February 2023.
You are regularized?
Yes, Lordship.
Why not paying pension?
Let me take instruction, Your Lordship.
(28) years. 12 P.T. Sama issue notice. Mr. Abraham for
1 to 5, Your Lordship.
And for 6. You have for 6 days after 4 weeks for instructions. I agree with this.
What place, Lordship?
Item number 5.
May I please, Your Lordship? Your Lordship, herein I am the petitioner aggrieved with the non-disposal of my representation letter dated...
Little louder. Yes.
Your Lordship, I am the petitioner here aggrieved with the non-disposal of my representation letter dated 6/02/2024
for?
Of representation for my husband's retirement pension. Yes, Your Lordship. The brief facts of this case is that, Your Lordship,
yes,
I, the petitioner, am the husband, I'm the wife of late Nalindro A. Sangma, Your Lordship. My husband joined the police service on 1st 6 1976, whereby
1976.
Yes, Your Lordship, and and whereby he was subsequently transferred to the 2nd MLP Battalion in Goiragre, and Your Lordship, he has served the police with utmost dedication and honesty, Your Lordship. However, Your Lordship, in the year 1993, my husband had applied for leave as a result of his sickness, Your Lordship, so as to avail medical treatment, and whereby it was acknowledged by the concerned respondent, and on his return to his service, he was not allowed to join. But instead, he was informed that a departmental proceeding was initiated against him.
Which year was this?
1993, Your Lordship.
1993.
Yes.
He joined in 76.
Yes, Your Lordship. He applied for leave in 1993, whereby he was not allowed to rejoin.
He didn't join back to his duties, that means, for a long time.
Yes, Your Lordship.
Yeah, then?
Instead, he was informed that a departmental proceeding was initiated against him for the unauthorized absence.
Yeah,
However,
then?
upon clarification of the facts, it was understood that he may be allowed to join. However, shockingly, he was not allowed to rejoin again.
Then?
Your Lordship, on the 17/09/2018, my husband expired, and I leaving me and my 4 children behind, and we have no other alternative source of income, Your Lordship. Thereby, we approached the concerned respondent with request to release the pensionary benefits of my husband, Your Lordship. To my surprise, I received a letter dated 26/06/2019, Your Lordship, whereby they informed me that he tendered his resignation on the year 1993. So to say, Your Lordship.
That resignation letter is with you?
No, Your Lordship.
They never supplied it to you?
No, Your Lordship. It was never supplied to me. Neither my husband nor the respondent. We have no knowledge. I have no knowledge about that, Your
So
Lordship.
they said he resigned, you won't be entitled to any pension. That's what they've told you?
That's what they told me, yes, Your Lordship.
You say that's not correct?
It is not correct, Your
They
Lordship.
showed you the resignation letter?
After his death, Your Lordship, I came to know about that.
No, did they show you? Did they give you a copy of your
Yes, Your
husband's
Lordship.
resignation letter? Where's that? You annexed it here? No, they said that they inform you that your husband had resigned in 93.
Yes, Your
And so
Lordship.
since ran 93, so he's not entitled any pension.
Yes, Your
But he
Lordship.
said that he went on leave in 93 and
He
then
went on-
joined back.
actually,
and then he
Your
went to
Lordship.
join, and what happened? Didn't allow him to join anymore.
No, Your Lordship. It was he was informed that he was informed that a departmental proceeding was initiated against him
You annex that,
for the
you annex that
unauthorized.
document here.
Yes, Your Lordship.
Where is that? Department proceedings.
Departmental proceedings.
Put it on the mail. Right here.
1993.
Yes. Okay, Annexure 3 was sent when? This representation. Dated? No date here.
This is the legal notice.
Annexure 3 was sent when? Your legal notice was sent when? This one?
Annexure 3. Copy of the legal
Let's see.
notice.
Which date is this? Which date is
It
the
was in
annexure?
the year 1993, Your
This
Lordship.
night is representation.
It is the legal notice.
Which year was it?
1993.
It is not written anywhere. The date the advocate signed. You sure?
Your Lordship, if I may, in the next chair, number 3, para 2.
No, para 2 is fine. When was this dated legal notice you sent? When was it sent to the police, to the department? You don't have record. You won't record.
No, Your Lordship.
Was it sent earlier on or recently?
Earlier, Your Lordship.
You see, you've written here that. See,
Yes.
para 7. You read para 7 of the at page 27 of legal notice.
Para 7.
Read so I can hear. Yes.
That it is unfortunate that Nalindro Sangma has expired on 17/9/2018 at Tura Christian Hospital after a prolonged suffering. It is also stated that my client's husband may be provided at least for invalid pension for his long period of suffering and to provide retirement benefit to my client, as the entire matter for alleged resignation has been manipulated. Some unscrupulous employee of your esteemed office, so through inquiry into this matter, is urgently required to find out the truth.
Read the rub till the end.
In view of the above facts and circumstances, I, on behalf of my client, request your esteemed office to conduct an inquiry into this matter, as my client's husband has not tendered his resignation letter dated 20/12/1993, Your Lordship.
They didn't reply to legal notice.
They
Do you have any other document showing that they received legal notice?
Your Lordship, please see annexure number 6.
They received it.
Yes, sir. They forwarded the letter to me, containing. Oh, sorry, Your Lordship. This is
another
not.
thing.
Yes, Your
This
Lordship.
is a letter number so and so containing order of the Northern Meghalaya High Court received from EIG.
Yes, Your Lordship.
But legal notice? What does it say? Join so and so and so and so. Let's see. Transfer.
I do not have it, Your Lordship. Your Lordship, my humble.
One second. One second. You're not receiving any money at all?
No, Your Lordship.
No terminal benefits?
No, Your Lordship.
Sure?
Yes, Your Lordship.
Yes. Ms. Lingwa.
Your Lordship, whether the legal notice was received or not, also there's no seal, Your Lordship. So I'll take instructions, Your Lordship, on behalf of Respondent 1, 2, and 3.
No, forget about legal. I'm just saying, they went legal notice, but then that they'd come to court also. WC 169.
Their
then
prayer
the
is
speaking
confined
order
only
passed
to-
that he resigned. So against this, they have not challenged this order. This is challenges now, the 21 order.
Your Lordship,
Because see what they've replied as per your earlier repetition. They have passed speaking order saying that as a matter of fact, this is you've received one after resignation of so and so was accepted by the Lieutenant Commandant. Ever since he has stopped receiving legal remuneration from the police department's death. The fact of receiving salary or was authority has not gone unnoticed to his family members. All the while during the lifetime of late Lansar, the issue had never been aired and taken up beyond the department. And that bring up this issue of financial hardship at this stage is beyond the scope of this office to provide solace. So,
Yes, Your Lordship. I humbly pray that please direct the respondent to dispose
no, of course, but the thing is that, there might be a futile writ. If they've already gone to the matter and in the earlier petition, they've already decided you have filed and then they've passed this order. Now you file
Yes,
another
Your Lordship.
representation on the same things, right?
Yes, Your Lordship.
So
They
you say that
totally
you didn't
neglected.
consider your representation, your earlier case properly. It was past 21, now 24. Yes.
I'll
Let's
take
take notice,
instructions.
just the instructions.
1,
Yes,
2, and 3,
your
Your
name?
Lordship.
L. Langi, Your Lordship.
L?
Langi.
Lani.
Yes, Your Lordship. Langi.
Yes, heard MS, first
L.
name?
Langi.
L. For the petitioner, issue notice. MS Eiling was present except for on behalf of
1, 2,
all the
and 3.
respondents. So no further notice required. And this is a matter of 3 weeks for instruction of the affidavit. So they give you a very tough case to argue.
Item number 6.
Well, MS,
Obliged, Lordship.
she'll argue the easy ones. Yes.
Much obliged.
Me, please, Your Lordship. Lordship, I prefer short passover, Your Lordship. Prefer short passover, Your Lordship.
What's the matter about?
Service matter, Your Lordship.
Yes, can be done, Mr.
We've
Paul's
take,
absence.
accept notice for 1 and 2, Your Lordship. And notice may be issued to the Lady King College. And the main, they are the
Well,
main
out of a job now.
respondents. He is under suspension,
Don't
Your
you-
Lordship.
You want interim orders?
Interim order, yes.
Let the senior come.
Shall pass over today or for the next one?
For today? Tomorrow?
Today, Your Lordship. At bottom of, let this matter come at bottom of the pot.
Say it then. You say you're seeing a Passover, I thought you wanted tomorrow, yes.
7.
Please, Your Lordship, I made a small mistake with one of the judgments that I wish to rely on. Will Lordships kindly have this tomorrow?
What happened?
I've made a prayer for recalling of the transfer orders, my lords. Because they represented before the appellate's court that the appellate's court have some sort of a conflict of interest, which is absolutely untrue. There is no conflict of interest. It's like saying that Lordships take up a matter at the stage of motion and the final judgment is passed by a different judge and Lordships are disabled from taking up the matter in the writ appeal. That's absolutely incorrect, my lords.
Does the contention?
This is a disingenuous plea.
No, but
The original suit was from 2003.
That was not heard before the district judge.
No, not at all.
It given reference here since they said it
No,
is able.
because, my lords, I have the order. They told the judge that you can't take up this matter because you've already heard this matter at some other stage. They could have heard the matter at a different stage of the proceedings, but that does not mean they're legally
Yes.
disabled from taking up the
I was
case.
hearing,
That is a disingenuous plea, my lords. This will set a very bad precedent.
No. I mean, you see, you can't mislead the district session
Not sure.
judge by saying that the
My lords,
district.
I have that order as well. Kindly see what it is not the court which is recused. They made this prayer before the court,
So then why did it send on reference here then?
which is what, my lords, they were, the court
What
perhaps
about
was
the earlier
misled.
orders already sent for the other matters already been sent on to Nongpo?
There, my lords, what has happened is
That's
that,
criminal revision, my lord.
again, there, I'm not sure what happened in those proceedings. That is a criminal case.
You're not there.
I'm not there at all. That is an FIR that they had filed. During the course of the execution, they participated in the execution, they left. They created a lot of commotion and law and order situation. Thereafter, they filed an FIR to derail the entire process by claiming that some items were stolen. How would they know? And the courts found everybody, whatever investigation was to be done was already conducted and an FIR was filed. Against that FIR, they filed successive applications. There's only a process to derail the entire execution. I'll take your lordships through the orders, my lords. Let's kindly see the order which has been passed by the learned trial court, which they're terming as a recusal order. That is at page 26.
Yes.
May I also kindly have the fourth paragraph. Learned counsel for the appellant submits. This is their submission. Learned counsel for the appellant submits that the instant appeal may be sent up in reference to the High Court of Meghalaya as self and Srimati R. Rimbai, Additional District Judge Shillong, had at one point of time taken up the matter when we were Assistant District Judge Shillong, and it may result in conflict of interest. How can this be a conflict of interest, my lord? And my lords, there is no order of recusal which has been recorded by the Additional District Judge. This is their prayer before the court.
You accept notice?
So I've already served. Kindly have it tomorrow. I'll place the judgment
Friday,
as well.
my lord. Friday, in the meantime, if required, my lord, I'll file my
Friday.
reply, my lord, Friday.
Friday is fine.
In the meantime, my lord, liberty may grant it to be filed.
Mr. S. and Mr. CCT Sangma is present on behalf of the opposite parties take notice. This is a matter for further orders on Friday.
Highly pledged.
But if that is correct, Mrs. Sangma, then that's a very unhealthy
No, my lord.
precedent. If you,
Yes,
you
my
know,
lord.
They are accusing me of several accusations, my lord.
you
Yeah.
can't browbeat the
No,
courts
no.
who say that, you know, you are disabled and then send a reference to the High Court, and they also send a reference here which has to be answered. And so if their finding is that they are disabled, then naturally it will result in a transfer to some other court.
No, my lord. Here.
So whereas most of the cases, this will be the result. In most cases. There are several cases which the district judge has taken up, which she has considered while she was assistant district judge. There is no conflict of interest as such.
I'll satisfy the court.
You bring the judgment?
Yes, Lord.
Item number 8.
Already here we'll be filing in the course of the day.
My lord, item number 8 and item number 4 of the daily list, they are similar matters, my lord. Item number 4.
Item 4 in
Of the
Delhi.
daily list.
4? Oh, I thought from that we got already over. Yes.
It's a similar matter, madam.
Yes, learned it also a moment. GA submitted. The affidavit will find the course of the day.
Yes, madam.
Yes. Same the other 8
Same.
also. You are there also.
Yes. Obliged,
No,
madam.
lord.
Daily list item number 1.
Yes.
Pending for respondent number 3, Your Lordship, the matter is listed today for the rejoinder arguments.
Yes.
Lordship, before my friend starts, if I can take 3 minutes to refresh my Lord's mind on the 3 issues I had raised, my Lord.
Your 3 minutes is
3 minutes. It'll be 3 minutes.
it's like expandable disk.
On the dot, my Lord. Just 3 issues I had raised as objection.
Okay, no, but you already filed a rejoinder, correct?
No, ma'am. They have filed a Order 7, Rule 11. We have filed a show cause to that.
They filed a.
So, against my...
To issue cause, they filed a rejoinder,
Yes,
correct?
they filed a rejoinder, my Lord. They filed a rejoinder. Now, hearing is almost complete. My friend had made her submissions. I had given my reply. So, in my reply, I had raised just 3 objections, my Lord.
How long will it take? MS Pallavi?
Your Lordships, around 20 to 25 minutes, Your Lordship.
We'll take up other matters first. Yes. We'll take it another one. Yes.
Item number 2.
Your Lordship, in this matter, we haven't received any show cause. In this matter, we haven't received any show cause.
It's CRP, there's no show cause. You're appearing?
Yes, Your Lordship.
Further?
For the respondent, Your Lordship.
For the respondent? Are the records necessary? This from which court? DF Marbanyam. What's... Oh, will they restore it?
A sick instruction, Your Lordship.
Seek instruction, not instruction, you don't need to seek instructions. It's dismissed for default. Why didn't appear for 10 days? What happened to Mr. Bora?
Yes, I was stationed.
You couldn't appear at that time.
Yes, Your Lordship.
You also didn't appear before trial court. So Nasi trial court got fed up. 10 days had gone by. Nobody is appearing, so they dismissed it. That means both parties not trusted, either the plaintiff or the defendant. But it goes to in your favor. See, you take instructions from me, senior. This case, see, the thing is that courts can't allow this kind of conduct by the counsels also. You can't be absent. You file a case, you can't be absent for 7, 8, 9 days. Correct? So the only order you've come again, it says that the many days absence suggests plaintiff no longer interested to proceed in some matter. File against a defendant, never entered appearance, decide to receive notice. You also never you receive notice, you never bothered to appear also. So both sides, they conducted the case very well. Held disposal of matters. Correct? You want for hearing? This matter for election hearing after 2 weeks. You bring your respective seniors.
Item number 31 is connected matter, Your Lordship.
No, wait, let him be called out. Yes.
Item number 3.
MS Inong Better. Yes.
I'm praying for some more time, my lord,
for what?
For filing rejoinder, my lord.
How many times you saw it?
2 times earlier, my lord. I'd called the petitioner for signing, my lord. Unfortunately, she is hospitalized and was in ICU just recently, my lord, 2 days back.
Okay, for the 2 weeks time granted for rejoinder.
Item number 5.
Yes, Mr. Sangma.
Please, Lordship, here I just need to file the rejoinder because here they have make a file an affidavit.
Some response allowed 2 weeks time file rejoinder.
Lordship.
Just thereafter.
Lordship. Must place, Lordship.
Item number 6.
Lord,
You are appearing now?
Lord, for 1, 3 and 6 only. Respondents number 1, 3 and 6.
We have served the
Taken steps on all of them?
Yes.
Number 2 received also? Number 2 is whom? 1, 3
and 6.
Parlang Power 1, 3 and 6. The only 3 respondents.
Lord, because in the suit there were 6 of them, and in the previous application I was 6.
No.
I do not have the application with me. I've just
have a look at this.
Who's 1, 3 and 6?
Mr. Bora's petitions, no? That he might give you a different one and file in the court a different one. In that, it's only 3. The limitation is an application of condemnation. Mr. Bora?
I reached.
You reached?
Yes,
congratulations.
For all the 3, my lord.
Yes. No, how many respondents have you made there?
Only 1. Only 3.
3?
3, my lord. Only 3. That is item 6, I think. Item 2 is... That's over.
This is item 6.
Okay.
No, because...
So 3 respondents are there.
They appeal for all these 3.
For the
not
3.
1, 3 and 6.
No, my lord.
Yes, Mr. Philemon Longbri.
Because in the CRP, there are 6 respondents, my lord. 3 have been in the application now, my lord, for condonation of delay, now there are 3 respondents. It's confusing.
Why, Mr. Bora?
Those 3 have to be removed from the CRP also, because we have found that they are not existing people in the village. We have filed on affidavit to that effect. So in the CRP also, I have to file
not
on
up for consideration because the limitation is still there, correct?
Yes.
Or it's in the other CRP?
So in the CRP cost same, title has to be same, changed, my lord. My lord, what had happened in this matter is the
very
condemnation was, my lord, dismissed, explaining the delay again. Now, my lord, the missed case for condemnation of delay which was dismissed, that has to be revived. He's filed now a fresh application, my lord. That's what I was asked to file a fresh condemnation petition by the order in the RA. It's okay, my lord. I'll enter appearance today. Once I get the copy of this application, I'll reply.
From the appearance behalf of all the respondents, such this is a matter for consideration and the prayer for interim, prayer for condonation. Yes, after 2 weeks. Yes. But Mr. Bora, at least be careful. All your petitions are on procedure and technicalities. They have become very confusing to the court.
Yes,
also.
those three will have to.
It's a question of three. Now you can't make people who are not exist in the village anymore parties. Then you say three. They're there in the main civil revision. Now in the Miss case, he said since those three don't exist, so you're not making a party here.
Yeah, those three have to be removed from the CRP also, my lord. I'll file one affidavit to that effect.
Yes, I think your advocacy, you've stretched the limits of advocacy procedures. Yes.
May it please your Lordship. Lordship, in this matter, Lordship, monthly pension of petitioner was stopped by bank due to non-submission of life certificate for 3 consecutive years, Lordship.
Where's Mr. Pandey?
Lordship, he's on legs. Lordship, Lordship, as per the instruction from the department, Lordship, the responsibility to resume petitioner's pension, it lies with Sonoli branch.
With the?
Sonoli branch, Lordship,
Where's the
bank.
Sonoli branch?
This is in, because the decision was given by SBI Sonoli branch, Lordship, so the responsibility to resume the petitioner's pension lies with that particular branch, Lordship. And respondent 1, 2 and 4 have no role to play, Lordship. So we
1, 3 and 4.
1, 2 and 4.
You're 1, 3 and 4.
1, 2, 5, Lordship, we are appearing.
1 to 5.
Yes, Lordship, but 1, 2 and 4, as per the department's instruction, we have no role to play, Lordship, in this matter. So Lordship may kindly allow us to file an application to strike the name of these respondents.
You can file an application you want, that's above consideration. But where's the petitioner? Let him come up first.
Yes,
let him come. And ask if you have the life certificate, then pension will be stopped. A proof of life, you mean?
Lordship.
Yes.
Item number 8.
May I please, your Lordship? We will file the rejoinder some more time, Lordship. No, Lordship. After 2 weeks, Lordship.
You only file your affidavit?
No, Lordship. The conducting counsel is unavailable to sign the Lordship. That's why I need a signature. My senior Lordship, Mr. K. Karmaplang, he's unavailable. So, signatures, I can't sign your Lordship.
Can't only file. You want to file the jointer?
Yes, Lordship.
So please, you will have to file the jointer to the affidavit file 125 MS. Please hold for the 1 week's time to file affidavit. Yes.
Highly obliged, Lordship.
Item number 9.
Yes.
Lordship, for respondents 1, 3, 4, 5 and 6, we have filed the affidavit, Your Lordship. In fact, the matter can be disposed of also, Your Lordship, if Your Lordship grants us some time to process the pension and
Yes, Mr. Deb.
release it.
Lordship,
what are you doing? Looking at the affidavit?
they have filed the affidavit, my lord. I'm sorry to say, but it seems even after filing of the petition, they have not really done anything. My pension has been hanging fire. I retired in 2018. 5 times the AG has sent reminders to the government. Now they are basically blaming the North. The Deputy Commissioner of East Garo Hills is blaming they say it's hanging fire, my lord. If Lordship is pleased to see the order of 7th of March.
1 second. What do you say in the affidavit, Ms. Yang?
Your Lordship, we have stated that most of the information that was sought for by the Accountant General's office has been collected and some are still pending to be collected.
Which paragraph?
That is in para...
Can you see para 14, my lord?
Well, see, Mr. Dev, I won't make a pension matter just unnecessarily linger here.
This is
because it just increases the delay.
Yes,
if you ask him for further instructions, ask him to explain.
No, they
if
should
we can
pay
give
it.
him a time frame, then
Yes,
let him finish the
yes.
due.
Yes, Your Lordship, we
whatever
already
it is,
asked
that's
you
the only
for that,
thing. Otherwise,
actually.
pension matters, this court,
Yes, yes,
you already know that we don't like to delay.
Kindly see para 14 at page 5 of the affidavit.
Yes, okay.
We're making all efforts to get the relevant information.
3 months.
3 months should be okay, Your
Yes.
Lordship.
Take down. This is an application. Your petitioner is still alive?
Yes, yes.
Is it? I mean the employee, sorry.
Yes, yes, yes. It's filed by the employee concerned.
This is an application for direction to the state respondents to take necessary action with regard to clarifications sought by the respondent number. Yes, Attorney General.
7, Your Lordship.
Respondent number 7. With regard to the preparation of pension papers of the writ petitioner. Stop. Who stated have retired on?
2018, Your Lordship.
Stop. Who retired since?
31st January 2018.
31st January 31/1018. Stop. Today, next paragraph, an affidavit has been filed on behalf of state respondents, especially number 6, wherein it has been categorically stated at para 14 as follows. So, quote number 14 as in a position. Stop. It is next one. It is noted in the statement of the respondent affidavit that the documents as required by the Office of the Accountant General has been received, and the only hindrance, the only prayer stage is for them to be allowed some time to process the same. In view of the statements made para 14, the state respondent directed to process to submit clarifications, and they expected that the entire process should be completed within a period of 3 months from today, and pension be afforded to the petitioner as due. Yes. Matter stands closed disposal.
Much obliged.
Item number 10.
Yes.
May I please, my Lord, praying for some accommodation for today, my Lord.
What's the matter about?
It's a boundary dispute between Four Village and the chief.
Oh, that.
Sora Seption.
Mapu.
My Lord.
Who's appearing from Mapu? The petitioner.
Tree Village.
Why accommodation? What's the matter for today?
I'm still waiting for instructions, my Lord.
You're waiting for instructions?
Yes, my Lord.
You're for respondent number?
1, 2, and 3.
1 and 3. District Council.
My Lord.
Yes, Mr. C.C. Jahamba submits that on behalf of 1, 2, 3, submits that instructions have not been received. The praise was allowed how much further 2 weeks time?
3 weeks time.
To obtain the same.
What
is thereafter?
Item 11.
Your Lordship, let the matter come up at the end of the board. Mrs. S. Bhattacharya is on legs in court number 1.
Your Lordship, it is just for filing of affidavit, Your Lordship, actually.
Your Lordship, I think on the last occasion some instructions were required to be placed before Your Lordship.
You made corrections in the court settle?
Yes, Your Lordship.
Why? I just noted that she was not present in court.
Your Lordship, the order before that, Your Lordship.
You're Mr. Nath.
Yes, Your Lordship.
The order before that? Or
Yes,
the
Your
order before
Lordship.
that? What's the matter about?
Termination of service, Your Lordship.
Termination of service.
Yes, Your Lordship.
Let her come. You will.
Obliged, Your Lordship.
Item 12.
Your Lordship, I need some time yet to have the instruction, Your Lordship.
How many times you sought Mr. Devnath?
The second.
File since when, Mr. Mupir? Mr. Devnath, please was allowed for the 3 weeks time to file affidavit. Please file it.
Lordship, insofar as the private respondents are concerned, I have taken steps. I may be allowed to file an affidavit with regard to the effect of service. I have taken steps on 16
Because
April.
usually There are no correspondence. Yes.
Because these are the juniors who have
7
proceeded.
to 10,
7
not
to 10.
received back. Lathwam, no? Yes, stop. Next paragraph. The office note also indicates that the ED cards not been received back for the private respondents number 7 to 10. Stop. Mr. Anangpur prays for is allowed to file an affidavit indicating service and set respondents before the next date. This also.
Second call, item 7.
Yes. You see, you haven't given proof of life to the bank.
Proof of life, Lordship? We have given, Lordship.
You sure?
Absolutely, Lordship.
Have you made a statement in your writ petition?
Lordship. We have.
Then they submitted that the fault lies with you. You have not given your proof of life to the bank. That's why your pension was stopped.
That is made in the prayer, Lordship. For 3 years, the petitioner failed to present himself before the concerned bank, Lordship.
Now you presented yourself.
Lordship,
When
Lordship.
did you present yourself?
This January, as recent as this January, Lordship.
Now who's appearing on behalf of the bank here?
Mr. Kharwan.
Who?
Ms. Kharwan Lang, I think.
Who's for the no for the bank?
S-Cream.
Cream, yes, Cream.
Where's the S-Cream? Because if you've presented yourself, or 3 years you didn't present.
Lordship, that's
the
why
reason. That's the reason to stop your pension.
Lordship. After that, subsequent to that, petitioner has presented himself, Lordship, every year, Lordship.
How old are you now?
60 plus, Lordship. 64.
He's quite young. It's not difficult to go to give.
Lordship, at that point of time, Lordship, he had suffered a fall, Lordship, and then he was partially paralyzed, Lordship. And he has subsequently recovered his health. Partially.
You called Mr. Khiriam. Where's Mr. Khiriam? Oh, you're appearing for the bank here. Then?
Your Lordship, I think we are not in this matter, Your Lordship.
1 to 5. This matter should be kept pending. All received 6, 7, 8.
Lordship, I think our name has been wrongly recorded, Your Lordship.
Wrongly shown. How be wrongly shown?
Lordship, if Lordship could kindly come to page number 24 of the petition, Lordship.
No, it's all right. What order dated?
Lordship, this is
Where the names were recorded?
8 April, Lordship.
8?
8 April.
8 April, Lordship.
Yes, Mr. Kapol for 6 to 8.
Lordship, actually, Mr. Idhar, Your Lordship. Idhar, Your Lordship. I was a proxy counsel, Lordship. My apology, Your
Who's
Lordship.
Idhar?
Idhar. He's one of our colleagues, Lordship, before.
Bidhar?
Idhar.
You inform him if you are listening to this matter tomorrow. Okay?
Lordship.
Yes,
My apology, Your Lordship.
it appears that there has been some confusion with regard to the counsel appearing for respondents 6 to 8. Stop. Mr. S. Khiriam, who had put in an appearance on 8/4/2024, submits that it is Mr. What's his full name?
Abhidhar, Your Lordship.
Abhidhar, who is the counsel 6 to 8. This is a matter for tomorrow. You can inform him. He's a local counsel.
Yes, Your Lordship.
Deeply all right, Lordship.
Pension matter, we won't keep it pending. What election? Where's Mr. Jindal?
Second, item number 1.
So wait for Passover. Orders. Yes, but Saji, she's not here. No, Millie.
Lordship, in this matter, if Lordship kindly recalls,
Yes.
If Lordship kindly recalls, my Lord, in their Order 7, Rule 11 application, they have taken 2 grounds.
That's miscase number. I think miscase. Yes.
We've taken 2 grounds, my lord.
Will it be on the I-22 or something? Yes. 2 grounds.
First ground, according to them, the allegation is that I was not present. The election petitioner was not present at the time of presenting of the petition.
As a registrar.
Second ground that they've taken, again according to them, the copies which have been supplied to them do not match the copies that have been filed, the petition that has been filed before this honourable court. In response, my lord, I have raised...
Okay, let's just understand again.
Yes.
They said that you're not present when your election petition is presented before the assistant registrar.
Yes.
Who designated the stamp reporter.
To the stamp.
Correct. And then there's no endorsement of the stamp reporter. Is that correct?
That's part of that same ground.
Please, Your Lordships.
Okay.
And secondly, according to them, the copies which have been supplied to them do not match the copies that have been, the copy of the petition that has been filed before this honourable court.
Also not true copy, Your Lordships. That is also an issue here.
And there was no marking. There was no, in the copy given to them, true copy was not written. The words true copy was not written. In response, my lord, I had extended 3 submissions. My first submission, my lord, was that the miscase that they have filed, that itself is not maintainable. Reason being, my lord, because under Chapter 8, Rule 10 of the Guwahati High Court rules, any miscase interlocutory application that is filed in an election matter requires the specific permission of the Honourable Court. In this matter, they had at one point taken permission to file a petition for amendment of pleadings or for striking out pleadings.
Order 6 Rule 16.
Yeah, yes, my lord. However, that petition was never filed. Instead, what they filed was an Order 7 Rule 11. So for Order 7 Rule 11...
So you mean to say that if they prayed for absolutely final Order 6 Rule 16, they didn't file it, they filed a 711, that means it's not maintainable?
7, no, my lord, because these are 2 completely different petitions.
Of course they're different. Yeah.
Completely different petitions. So first point being, miscase itself is not maintainable because there is no permission.
There's no permission, yes.
As is mandatorily required under High Court rules, my lord. Second objection that I had taken was that the petition filed under Order 7 Rule 11 does not conform to the statutory requirements.
Okay.
Order 7 Rule 11...
What is the new submissions they're making now?
No.
With regard to non-penibility, like they ask for another prayer. So you have not.
I've humbly pointed out on the last occasion. I pointed out the specific order by which Lordship was pleased to grant them permission to file striking out petition.
Okay.
So all that is there, my lord. Second objection that I had taken was Order 7 Rule 11 petition does not conform to statutory requirements.
Which way?
First, the first reason being that under Order 7 Rule 11D, under which the petition has been filed, what is required is, what Order 7 Rule 11D contemplates or states, is that a plaint can be rejected if it appears from a statement in the plaint that the plaint is barred under law.
Okay, yes.
My point was very simple, that in the voluminous submissions that were advanced by the other side, not a single instance was there when the plaint was picked up to show the statement in the plaint.
Yes.
And the second point...
Barred by law.
Barred by law. And the second point in this, under this ground itself, under this point itself, was that they state, according to them, they state that the bar under law, according to them, is under 86(1) of the RP Act. My response, my humble response to that was that 86(1) is not a bar as contemplated under CPC. Under CPC, specifically Section 9, which I had humbly taken my lord through, the bar contemplated under CPC has to be a threshold bar. Something that prevents cognizance being taken, in other words, something that prevents me from even entering the portals, the halls of the court, my lord. 86(1) is not such a threshold bar. 86(1) is an empowering provision that empowers this honorable court to dismiss an election petition, but after cognizance has been taken. So in this matter, notice has been issued under the provisions of the RP Act, cognizance has been taken. That being the case, the stage of raising an issue of a threshold bar is long gone, my lord. So 86(1) cannot be the bar under law, which is again required under Order 7 Rule 11D, my lord. That was my second point, my lord. My third point was on the merits of the allegations which they had raised. First allegation was I was not present. My simple answer, very simple answer to that was I was present. So it comes down to a question of evidence, my lord. It comes down to a question of evidence. Also, my lord, I had humbly pointed out that there is an office note dated 21st March 2023 which states that all objections have been complied with. That being the case, my submission before this...
Where's the office note? Is here on the file itself?
It is there. Lordship had gone through it, my lord. So 21st March 2023, it says that objections have been complied with.
3/23, that objections have been...
So it's not really an office note, it was a checklist, my lord. That,
yeah, but the checklist, that's a general checklist.
Yes, ma'am. So my contention was that there should be a presumption of compliance.
Yes.
And all these submissions, my lord, from the beginning till the end, I had placed case law, supporting case law also, my lord.
Yes.
So my first point was that because of that checklist, because of that office note, there should be a presumption of compliance backed up by judgments of the Supreme Court. The specific allegation that I was not present, my simple answer to that is I was present. Their sub-allegation was that I had not presented it, even if I was present, I had not presented it to the stamp reporter. My response in my show cause was I had presented it to Mrs. Lanong, who according to me is the stamp reporter. Specific query was raised on them by my lord that if you are saying Mrs. Lanong is not the stamp reporter, who was the stamp reporter? They have no answer to that, my lord.
Okay.
So that was the first submission on merits, that on whether or not I was present. I state I was present. It comes down to a question of evidence, my lord. Second contention of theirs on merits was that the copies are different. The copies given to them are different from the copies given to and the words true copy are missing. I had relied on a constitutional bench judgment of the Supreme Court in 1999, 4 SCC 274.
1999? You given copies?
Yes, ma'am. Yes, it's there in the compilation. There is a big compilation, my
lord.
Page? Page 274.
Okay. Yes.
It is at page 41 of the compilation, which is there before, my lord. Now, this constitutional bench judgment, it's a very important judgment, my lord, because it addresses all these issues which are being seized off by my lord. The first thing that this judgment states is...
Yes.
The first thing that this judgment states is that it brings up the question of substantial compliance. It brings up the issue of substantial compliance. It invokes or lays down the principle of substantial compliance. As long as there is substantial compliance with the provisions of the RP Act, that is more than enough. Number one. Number two, it says that in case any allegation of defect, etc., is being raised by the opposite party, by my friend, they have to plead and show that they were misled by these defects and it prevented them from raising a defense against my election petition. So even assuming, just for the purpose of argument, that what they're saying is true, that true copy, the words were missing, did it mislead them in any manner? Did it mislead them in any manner? And did it prevent them?
So judgment, it touches upon those points?
It does, in detail, my lord.
Where's the compilation?
It should be in the record, my lord.
It's not here with the court. Oh yes. What page is it?
This is at page 41 of the compilation.
Sorry, yes.
Should I take, my lord, through this judgment, because it sort of seals the matter. Page 41, T.M. Jacob, my lord.
Yes, yes. Yes.
Page 41, paras 33 onwards, my lord.
Two copies.
That is at page 58 of the compilation itself, para 33, my lord. I'll quickly read, my lord, if lordship allows. Para 33, does the word copy occurring in section 81(3) of the Act mean an absolutely exact copy, or does it mean a copy so true that nobody could, by any possibility, misunderstand it? This matter is no longer res integra in Murarka Radhesham Ramkumar versus Roop Singh Rathore, a constitution bench of this court elaborately dealt with this question after referring to a catena of authorities. It was held that the test to determine whether a copy was a true one or not was to find out whether any variation from the original was calculated to mislead a reasonable person. The Constitution Bench found as untenable the contention that since copies of the petition served on the returned candidate did not contain the signatures of the petitioner below the word petitioner on the copies of the petition served on the respondent, they had ceased to be true copies of the original petition, attracting the consequences of Section 86(1) of the Act. The bench opined. It goes on, my lord. So, the test laid down by the Constitution Bench is whether the variation from the original was calculated to mislead. No such calculation can be inferred, can be argued, can be claimed, my lord. Para 35, my lord.
Yes.
Para 34, it speaks of substantial compliance. I'll jump to para 35, my lord. The object of serving a true copy of an election petition and the affidavit filed in support of the allegations of corrupt practice on the respondent in the election.
The parties come to next 61, the first para, last year, there's thus been substantial compliance with requirements Section 81(3) that provides with Section 81 so and so.
Yes, my lord.
Defects supply of copy.
Yes, page 61, just above the dotted line, I'll read, my lord.
That's what, yes.
Defects in the supply of true copy under Section 81 of the Act may be considered to be fatal, where the party has been misled by the copy on account of variation of a material nature in the original and the copy supplied to the respondent. The prejudice caused, it goes on. No such allegation, no such pleading, my lord. Para 39, my lord.
This para 37 is important.
Para 39,
yes.
On page 62. Applying the test as laid down in Murarka so to the fact situation of the present case, we come to the conclusion that the defects complained of in the present case were not such as could have misled the appellant at all. The non-mention of the names of the notary or the absence of the stamp and seal of the notary in the otherwise true copy supplied to the appellant could not be constituted to be an omission or variation of a vital nature and thus affect the defect. If at all it could be construed as a defect, was not a defect of any vital nature. Rajab, I'll just skip a few lines if I'm allowed. Next page, in this connection. In this connection, it is also relevant to note that the appellant neither in the memo of objections nor in the written objections or in CMP number so-and-so has alleged that he had been misled by the absence of the name, rubber stamp and seal of the notary on the copy of the affidavit supplied to him, or that he had been prejudiced to formulate his defense. Same is the case. No such pleading is there, my lord.
Yes.
And lastly, para 40, just 2 lines from here, my lord. In our opinion, it is not every minor variation in form, but only a vital defect in substance which can lead to a finding of non-compliance with the provision of Section 81(3) of the Act, with the consequence under Section 86(1) to follow. The weight of authority clearly indicates that a certain amount of flexibility is envisaged. So, my lord, going back to the principle of substantial compliance, which has been enshrined in this Constitutional Bench judgment, following this, my lord, there have been some judgments from high courts, more particularly Jharkhand High Court, which also we had submitted. Citation being, my lord, 2012 SCC Online, Jharkhand 1385. This deals with the exact same contention raised by my friend in our case. In this case also, the allegation was that the supplied copies did not have the words true copy. Dealing with that contention at page 4 of this judgment.
Yes, presentation of petition.
Yes, my lord. I'll just skip most of it, my lord. I'll go to the last 2 lines, second last line, my lord, on this page, page 4. The election petition was typewritten, and the copies which accompanied the petition were carbon copies of the typescript. Each of the copies bore the signature of the petitioner. The petitioner had not, however, inserted the words true copy before or above his signature. On the said facts, the Honorable Supreme Court, without going into the question whether Section 81(3) of the Central Act or any other portion of it was merely directory or mandatory, held that the signatures in original found on the copies were intended to authenticate the documents to which they were appended, and that in the circumstances of the case, the absence of the words true copy above the signature of the election petitioner in the copies was not fatal, and hence the court had held that there was substantial compliance with the requirement of section 81(3) of the Central Act. Next para, my lord. Here in the instant case, the documents appended to, although have been attested to be true copies, but every page of the petition accompanied by original copy did not bear the attestation, true copy of the petition. Though on each and every page, signature of the petitioner is there. Same in our case, madam. Since the signature of the petitioner is there on each and every page of the copy of the election petition, it, in terms of the ratio laid down by the Honorable Supreme Court in the case referred to above, can easily be said that the signatures were put in intending the petition to be a true copy of the original, and thereby the aforesaid defects can never be said to be fatal. So the copy supplied to my friend...
So you mean to say that the hyper-technical aspect of this has to be overlooked and presumption of compliance has to be there?
Hyper-technicality, if that is the correct word, should be avoided, my lord.
So presumption of compliance.
Presumption of compliance and, my lord, substantial compliance, as per what the Constitution bench has said. So in our case, my lord, the copy supplied to my friend...
So, okay, and there will not be this allegation, so this is but a small side thing.
Yes,
only thing is that presentation, that's the only thing.
Yes, madam.
That is...
the circumstances...
That requires, because that will settle the deal also.
The circumstances being, my lord, it will require evidence, because if Lordship recalls, a petition was filed by them at one point in the midst of these proceedings, asking for the CCTV records to be preserved. It was too late in the day, because that was filed months after the tapes were deleted. So it'll have to come down to evidence. The stamp reporter will have to stand before my lord and say that yes or no.
What are the other order passed by this court only?
Yes, my lord.
In which case was that?
That was, my lord,
James.
in election, Gavin Miguel Milliam, my lord.
Oh, not okay.
And also James Sangma, I think.
Same order was passed.
Same. The Lordship had opined, or Lordship had stated that maybe the issue of presentation can be taken as a preliminary issue, but in this interlocutory application case, it cannot be decided in the absence of evidence. So my friend had taken some time to give a rejoinder
Can
to...
I make my submission?
Yes, Ms. Pallavi.
Please, Lordship.
Yes. Only rejoinder submission. Have you got the judgment? Have they given you a copy of the judgment?
Yes, Lordship, I have the compilation.
Jharkhand judgment, have you seen it?
The
Jharkhand judgment, have you seen it? It's a very telling judgment.
That judgment I do not have right now, but I have the compilation, Your Lordship, which my learned friend had placed it on record on the last occasion. That I have.
Right.
But the Jharkhand judgment I don't have.
Yes. Okay.
With Your Lordship's permission. So, Your Lordship, on the last occasion, I had argued on my application saying that the present petition is liable to be dismissed in view of non-compliance with the relevant provisions, which is Section 81 and Section 82 of the and Section 83 of the Representation of People's Act. Yes. Now, Your Lordships, not just that, also this petition has not been filed in terms of Article 329B of the Constitution of India and Chapter 8A, Rule 1 of the Guwahati High Court rules, Your Lordships. So, Your Lordships, in brief, my submissions were that in points I would highlight, Your Lordships, that there has been no personal presentation, that is, there is a violation of Section 81 Clause 1. Then the presentation has not been made before the stamp reporter, duly authorized by this court, Your Lordships. There is no endorsement, Your Lordships. Then the petition has not been attested by the petitioner under his own signature to be the true copy of the petition, Your Lordships. Also, no identical copies have been served on me, Your Lordships. So there is a clear violation of Section 81 Clause 1. So far Section 82 is concerned, Your Lordships, only the respondent number 3 had to be arrayed as a party in terms of Section 82 of the Representation of People Act, Your Lordships. But therefore there is no compliance of Section 82 also and Section 83, Your Lordships. Now, therefore, in my humble submission, this petition is liable to be dismissed under Section 86 Clause 1 of the Representation of the People's Act, which acts as a threshold bar, Your Lordships.
Right.
Now, Your Lordships, coming to the submissions which were made by my learned senior friend on the last occasion, Your Lordships. Your Lordship, the first argument which was taken was that there is no permission to file. Your Lordships, kindly have page number 31, that is Rule 10, page number 31 of my miscellaneous application, Your Lordships, that is Rule 10 of Chapter 8A, Guwahati High Court Rules.
Yes.
Your Lordships, Rule 10 says, all interlocutory petitions should bear a court fee stamp of ₹6 thereon and may be filed before the judge with permission of his Lordship.
Yes.
Your Lordship, it does not say shall, it says may. And in Catena of Judgments, Your Lordship, the Honorable Supreme Court has distinguished the meaning of may and shall. So, Your Lordships, in my humble submission, this particular provision is not binding as such. It uses the word may, Your Lordship, it does not use the word shall. Now, Your Lordship, moving to the second submission which was made by my learned senior friend, Your Lordship, that is whether Section 86 acts as an absolute bar and Section 9 CPC was relied upon by my learned friend, saying that the Section 9 of the CPC says that the courts to try all civil suits unless barred. Your Lordships, in my humble submission, at a prima facie, I would like to say that, Your Lordships, this particular provision does not confer power on election petitions. Your Lordships, on that aspect, kindly have page number 42 of my miscellaneous application, Your Lordships. That is a reproduction of, that is a judgment, G.V. Sri Rama Reddy versus Returning Officer, Your Lordships. Kindly have page number 42.
Para?
Page number para 16, Your Lordships. The relevant is para 18, but I would read from para 16. Para 16 says that while interpreting a special statute, here the special statute is Representation of People's Act, Your Lordships. While interpreting a special statute, which is a self-contained code, the court must consider the intention of the legislature. The reason for this fidelity towards the legislative intent is that the statute has been enacted with a specific purpose which must be measured from the wording of the statute strictly construed. The preamble of the Representation of the People's Act makes it clear that for the conduct of election of the Houses of Parliament for the legislature of each state, the qualification and disqualification for membership of those houses, the corrupt practice and other offences in connection with such allegations, the Act was enacted by the Parliament. Now, this is a very relevant paragraph, Your Lordship, para 18. In spite of existence of adequate provisions in the Code of Civil Procedure relating to institution of a suit, the present Act contains elaborate provisions as to disputes regarding elections. It not only prescribes how election petitions are to be presented, but it also mandates that what are the materials to be accompanied with the election petition, details regarding parties, contents of the same, relying that may be claimed in the petition, and how trials of election petitions are to be conducted has been specifically provided in chapter so and so. Your Lordship, therefore, in my submission, CPC is not the act which is entirely, these particular proceedings are not being governed by the CPC, Your Lordships. It is being governed by Representation of People Act, and that is why my application, it is Order 7 Rule 11D read with Section 86, which is exclusively governing the present proceedings, Your Lordship. So therefore, now even if Section 9 is read, Your Lordship, Section 9 says either expressly or impliedly barred. Your Lordships, Article 329B of the Constitution, Section 86 of the Representation of People Act, Chapter 8A, Rule 1 of the Guwahati High Court Rules. All these three provisions read together, they are absolute bar on the election petition if they are not filed in compliance with the provision of in compliance with the relevant provisions of the Act, that is Section 81, 82 or 117, Your Lordships. Therefore, Your Lordships, in my humble submission, it is a gross misinterpretation being given to Section 86 that it does not act as a threshold bar. It is a threshold bar, Your Lordships, and also Order 7 Rule 11D, the present application has been read with Section 86, saying that the petition is liable to be dismissed, Your Lordships. Now, Your Lordships, my learned senior friend has relied on the judgment. This is the page number 26 of the compilation which has been provided by them, Your Lordships, on the last occasion.
Yes.
That is Patel Ahmad Mohammed versus Balwant Singh Rajput. Your Lordships, before that, my learned senior friend was relying on 1999 judgment, that is a constitution bench judgment on doctrine of compliance and doctrine of curability. Your Lordships, after that judgment, number of judgments have been passed by the Honorable Supreme Court of India, establishing that Section 86 acts as a threshold bar. For example, Your Lordship, the present judgment, Patel Ahmed Mohammed versus Balwant Singh Rajput, at page number 26 of the compilation, Your Lordship. In this judgment, what had happened, the relevant, certain office objections were not cured by the registry, and it was the petition was placed before the Honorable Gujarat High Court. The High Court had held in para 12, Your Lordships, para 11 and para 12 at page number 35 of the compilation, Your Lordships. In these paras, basically, the Honorable High Court has observed that since the petition was produced before the Honorable Court, so it would be presumed that the necessary steps have been taken by the registry, and then there was a presumption. Your Lordships, here the issue was whether the issue was very similar, that whether the copies were true copy or not. On that aspect, Your Lordships, in that case, what had happened, the photocopy was filed by the applicant to prove whether there is a true copy or not. On that aspect, Your Lordships, Honorable Supreme Court, starting from para 16 at page number 37, Your Lordships, of the compilation, in those paragraphs, Your Lordship, the Supreme Court has categorically held that the true copy cannot be examined on the basis of the photocopy, and for that, original is to be filed. Your Lordships, on that very aspect only, Your Lordships, kindly have para 20.
Yes.
In para 20, Your Lordships, in para 20, Your Lordships, the Honorable Supreme Court says that in the event the appellant is in a position to persuade the High Court to allow the said application, the election petition will have to be dismissed at the threshold under Section 86 Clause 1, read with Section 81 Clause 3 of the Act. Your Lordships, para 20.
Okay. Where does it say that? The election is not disclosed cause of action.
Please, Your Lordships, kindly have, it is para 20, Your Lordships, page number 38. Yes. Your Lordships, in this case, what had happened, the Honorable Supreme Court has remanded back the matter to the High Court to ascertain the issue whether the copies filed were true copy or not.
Okay. Yes.
Your Lordship has it? Yes.
Yes. Yes. Carry on.
Yes, Your Lordship. So in para 20, the para 20 reads, Your Lordships, as we are inclined to relegate the parties before the High Court for consideration of election application number so-and-so afresh in accordance with law, and in the event the appellant is in a position to persuade the High Court to allow the said application, the election petition will have to be dismissed at the threshold under Section 86 Clause 1, read with Section 81 Clause 3 of the Act. Your Lordships, in my submission, there are two points which are very clear with this particular paragraph. First, Section 86 acts as a threshold bar, and the election petition is liable to be dismissed if the same is not within the parameters of the provisions of the Representation of People Act. Secondly, Your Lordships, the theory of presumption is absolutely incorrect, Your Lordships. It cannot be presumed because the judgment my learned friend is relying on is 1999. Your Lordships, this is also a Constitution Bench judgment. This is of 2018, Your Lordships. In this judgment, Your Lordships, the true copy, in my humble submissions, Your Lordships, the issue, whether it is a true copy or not, it is a material question of law which is to be decided by this Honorable Court. And if the same is not established, then Your Lordships, in that event, the petition is liable to be dismissed at the threshold under Section 86 Clause 1, read with Section 81 Clause 1 of the Representation of People Act, Your Lordships. Now, moving on, Your Lordships, to the, please, Your Lordships. Now the next submission was with respect to who is the stamp reporter. Your Lordships, I categorically submit that the presentation has not been made personally by the petitioner, and it has not been made before the stamp reporter. Your Lordships, I have also attached the order dated 30th of March 2022. That is passed by the Registrar General along with my Order 7 Rule 11 application, Your Lordships, which I have relied upon on the last occasion also. That the stamp at the page number 36, Your Lordships, which says that the Assistant Registrar 3 is the stamp reporter who has been duly authorized by this Honorable High Court, before whom the presentation has to be made. Now, Your Lordships, in my submission, the petitioner states that Srimati S. Lano was the assistant registrar, the concerned assistant registrar before whom the presentation is to be made. Your Lordships, now I say it is the onus lies on the petitioner. The petitioner has not placed any notification or any order as such before this honourable court, which substantiates, which proves that she was the concerned stamp reporter, or she was the assistant registrar 3 before whom the presentation was to be made, Your Lordships. Now, Your Lordships, the next point, Your Lordship, the next point, a very relevant point, is that in the entire arguments, Your Lordships, on the last occasion, my learned senior friend has conceded to the fact, basically he has admitted that there is no endorsement. And if Your Lordships, in that respect, Your Lordships, my only submission is that if there is no endorsement, Your Lordships, then there is no personal presentation, Your Lordships. On that aspect also, Your Lordships, there is no personal presentation.
Okay.
No endorsement by the stamp reporter, Your Lordships, that was submitted by my learned friend on the last occasion, that there is no endorsement. Your Lordships, from the entire arguments which was addressed by my learned friend today also and on the last occasion, it transpires that they are admitting that there are certain non-compliances with the relevant provisions of the Representation of People Act, which is not mandatory in their opinion,
which should be
and
excused.
Therefore it should be presumed.
Yes, they say which should
Please,
be
Your
excused. Which should be excused
Please,
according to them.
Yes, they should not just be excused, it also should be presumed that since the matter has been placed before this honourable court, the defects have been cured. Your Lordships, however, this is not the case, and I have distinguished from their own judgment only, that is Patel Ahmed, Your Lordships, that is 2018 Constitution Bench. Now, Your Lordships, and also, Your Lordships, it is a very relevant point here, Your Lordships, also this the order dated 30th October 2023 passed in election petition 2 of 2023, Your Lordships, that order was passed by this honourable court only in para 11, in para 12, Your Lordships. My learned friend is carrying the copy.
Slow down a bit, yes. Para 11.
Para 12, Your Lordships, that is page number 9 of the judgment. This judgment has been passed by Your Lordships only, and Your Lordships has categorically held in para 12, Your Lordships, page number 9.
Yes. Yes.
A perusal of the above noted judgments, therefore, and Your Lordships, the judgments were Abdul Jabbar, Jamaluddin, and G.V. Srirama Reddy, Your Lordships. These judgments, which I had argued on in detail on the last occasion, Your Lordships, the perusal of the above noted judgments therefore leaves no doubt as to the stringent requirements that are to be followed in filing and presentation of an election petition, in as much as observed by the Honourable Supreme Court, an election petition is a serious matter with a variety of consequences. Your Lordships, this observation has been made by this Honourable Court only and duly affirmed by the Honourable Supreme Court of India. Your Lordships, therefore, the argument that it has to be presumed if the matter is kept before this honourable court, the defects are cured, it has to be dismissed at the outset, as Section 86 acts as a threshold bar under Representation of People Act, Your Lordship, for dismissal of any election petition if it is not being compliant with Section 81, Section 82 and Section 83 of the Representation of People Act, Your Lordships. Now, the next submission, Your Lordship. Also, Your Lordship, they have relied on the judgment, that is Muraka Radhe Shyam Ram versus Roop Singh Rathod, Your Lordships, that is at page number 69 of their compilation. This judgment is completely irrelevant, Your Lordships, that I would say, because at this occasion, Your Lordships, when the judgment was passed, it was passed in 1964. This judgment was passed in 1964, Your Lordships, and that time Section 82 did not even exist. This judgment is in respect of Section 90. After, in 1966, when the amendment was made in the Representation of People Act, Your Lordship, Section 82 was included. So therefore, this judgment has no relevance and it is not applicable in this case, Your Lordships. The another judgment which my learned friend is relying upon, Your Lordships, that is at page number 77. This is Ajay Arun Singh versus Sharadendu Tiwari, Your Lordships. This again, Your Lordships, I would say it is not relevant in the present case, Your Lordships. In this case, what had happened, after dismissal of the Order 7 Rule 11 application, an averment was raised by the applicant therein with respect to non-filing of an affidavit which was mandatory. So here, this is not the case, Your Lordships. In this case, the Order 7 Rule 11 application is still pending and the arguments are still going on, Your Lordship. That's why this judgment has no relevance and it cannot be applied in the present case.
Okay. Anything else?
Your Lordship, these are my rejoinder arguments, but also I am relying on few more judgments, Your Lordship. My learned friend has the copies of these judgments.
Yes. The reserved orders, yes.
Lordship, can I quickly respond?
Your Lordship,
No more
also
response.
there is one more submission. Your
Yes.
Lordships, also there is one more submission. It is an important submission because in election petition 2 of 2023, Gavin, Your Lordships, in that case, what had happened, the petitioner therein had at least moved an application seeking cure of defects. In this case, that has also not been done. And on the contrary, there has been admission on the part of the petitioner that the defects have not been cured, and therefore it should be presumed that they have been cured since they have been produced before this honourable court, Your Lordships.
They're not saying really defects. It's just that's why they're just saying that substantial compliance. We have to, it's all around that. It revolves around that term only. Whether this court, in its discretion, can consider it, but taking account the judgment of constitutional bench. Anyway, we'll see.
Your Lordships Your Lordships on section 86 as a bar also, I am relying on few judgments, Your Lordships.
Yes.
The copies of those judgments
Threshold bar.
is having.
Yes. Which one? Which judgments are those?
The petition is, it does not exactly say threshold bar, but yes, the petition is liable to be dismissed if there is no compliance with the relevant provisions, that is section 81 or 82 or 117, Lordships.
23.
There is one, please, Your Lordships, there is one Dharmin by Kashyap, Your Lordships, 2023 judgment. This is also passed by the Honorable Supreme Court. Your Lordships, kindly have para 12.
Yes.
Your Lordships, para 12, it says, it is in respect of the Representation of People Act only, Your Lordships. It is well settled principle of law that where a right or a liability is created by a statute, which gives a special remedy for enforcing it, the remedy provided by the statute must be availed of. It is also well settled statutory principle that if a statute provides for doing a thing to be done in a particular manner, then it has to be done in that manner and in no other manner. In Cherokee Money versus Narendra Chaudhary, it is observed that where the law prescribes a thing to be done in a particular manner following a particular procedure, it shall be done in the same manner following the provisions of law without deviating from the prescribed procedure, Your Lordships. Now, in para 15, it says, Your Lordships, Your Lordships has para 15.
Yes. There's hardly any need.
There is hardly any need to reiterate the right position of law that when it comes to the interpretation of the statutory provisions relating to election law, jurisprudence on the subject mandates strict construction of the provisions. Election contest is not an action at law or a suit in equity, but purely a statutory proceeding, provision for which has to be strictly construed. The petitioner having failed to make any application in writing for recounting of votes as required under section 80 of the Nirvachan Niyam 1995 and having failed to seek relief of declarations as required under so-and-so, the election petition filed by the petitioner before the subdivision officer seeking relief of recounting of votes alone was not maintainable, Your Lordships. Similarly, in another judgment, Your Lordship, that is Lakshmi Singh and others versus Rekha Singh. This is again 2020, Your Lordships.
Where's the judgment? Citation, the judgment.
Your Lordship, please, Your Lordships. It is 2020, Volume 6, SEC 812.
812.
Yes, Your Lordship. Your Lordships, in this judgment also in para 13, the Honorable Supreme Court has held
yes,
that it is a tried position of law that when it comes to the interpretation of a statutory provisions relating to election law, jurisprudence on the subject mandates construction of the provisions. In Banwari Das Samarchand, referring to the Delhi Municipal Corporation Act 1957, it was observed that an election contest is not an action at law or a suit in equity, but purely a statutory proceeding, Your Lordships. Your Lordship, this is also my argument to my learned friend who is relying on Section 9 CPC, Your Lordships. That is why I am saying that Section 9 CPC is not entirely applicable in the present proceedings, because the Representation of People Act is a self-contained code. And therefore, the provisions laid therein have to be mandatorily be followed and applied here in Your Lordships.
Yes.
Now, the another last judgment, Your Lordships, I am relying on is
Yes.
this is another judgment. This is the last judgment, Your Lordships. Shams Khwaja versus Election Commission of India. This is 2002 SCC online. This is Uttarakhand, Your Lordships.
Yes.
Your Lordships, kindly have para 3.
Yes.
Para 3, Your Lordships, it states the question before this court at the threshold is as to whether the present election should be dismissed under subsection 1 of section 86 for non-compliance of the provisions of section 81 of the Representation of People Act. Article 329B of the Constitution of India sanctifies the people's will to elect their own representatives to provide the governance from the country's highest law-making bodies, the Parliament, and either house of a state legislature. It also restricts the scope of challenge to such an election only by a formal election petition presented to such an authority and in such manner as may be provided for, by, or under any law made by the appropriate legislature. Thus, the right to challenge an election is a right provided under Article 329B of the Constitution, which provides that no election to either House of Parliament or to the House or either House of the Legislature of a state shall be called in question except by an election petition presented to such authority and in such manner as may be provided for, by, or under any law made by the appropriate legislature, which is the Representation of People Act, Your Lordships, in the present case. Your Lordships, kindly come to para 11, Your Lordships.
Conjoint reading.
Yes. Please, Your Lordships. A conjoint reading of section 80, 81.1, 86.1 of the Act in the light of Article 329B of the Constitution of India, it is clear that the provisions contained in subsection 1 of section 81 of the Act is mandatory in nature as under section 80 of the Act. It has been provided that no election shall be called in question except by an election petition presented in accordance with the provisions of this part. Section 86 of the Act provides that the High Court shall dismiss an election petition which does not comply with the provisions of Section 81, Section 82, Section 117. Your Lordships, I would want to pause here and would want to highlight that it is not all the three of the provisions have not to be complied with. It is either Section 81 or Section 82. In the present case, Your Lordship, both the provisions are not being complied with, in my humble submission, Lordship. Now, Section 81 provides the presentation of the election petition, and if the election petition is not presented according to the provision given under subsection 1, the petition is liable to be dismissed. Your Lordships, in para 12, the Honorable Supreme Court relies on Satyanarayan versus Dhujaram, reported in AIR 1974 SC 1185, held as under the right to challenge an election is a special right conferred under a self-contained special law, and the court will have to seek answer to the questions raised within the four corners of the Act. And the powers of the court are circumscribed by its provisions. An election petition cannot be equated with a plaint in a civil suit, Your Lordship. This is very relevant. Thus, a strict compliance of provisions of Section 81 of the Act is mandatory, and an election petition must be presented to the High Court by the election petition in person, Your Lordships, and in para 16, Your Lordships. Your Lordships, as para 16.
Yes.
Yes, para 16, Your Lordships, after the amendment by Act 47 of 1966, the subsection 2 has been taken away, which earlier contained manner of presentation of election petition before the Election Commission. Under subsection 2 of section 81 of the Act, before its repeal, the election petition was to be presented by the election petitioner himself or by his authorized person in writing in that behalf, or it could be sent through registered post. But the legislatures have deliberately withdrawn the aforesaid manner of presentation. The intention of the legislature is clear, that the legislature did not intend to provide for a presentation of election petition in the manner contained in subsection 2 before the High Court also. The legislature strictly made the presentation of election petition to be made in accordance with subsection 1 of section 81 of the Act. It is settled rule of interpretation that where express provisions are made by a statute, the doctrine of implied power cannot be invoked to supply the provision which has been deliberately omitted, Your Lordships. Now, in para 21, Your Lordships, the Honorable Supreme Court further observed that a question arose before the Apex Court as to whether the election petition presented to the registry by advocate's clerk in the immediate presence of petitioner was valid presentation. In the case of Shyodan Singh versus Mohanlal Gautam, the Honorable Apex Court in its judgment reported AIR 1969 SC 1024 held it to be substantial compliance at the time of presentation of election petition. The petitioner was present. Para 4 of the judgment reads as under, the High Court has found as a fact that the election petition was present to the registry by an advocate's clerk in the immediate presence of the petitioner. Therefore, in substance, though not in form, it was presented by the petitioner himself. Hence, the requirement was fully satisfied. However, Your Lordships, in para 25, Your Lordships, this is the final observation made by the court. In view of the above discussed legal position and backdrop facts noticed above, there is no escape from the conclusion that there was no presentation of the election petition in accordance with provisions of section 81(1) of the Act. Even today, none is present before the court when the case is listed before me, and then it was accordingly dismissed under section 86 clause 1 of the Representation of People Act, Your Lordship. Therefore, I would conclude my arguments by saying, Your Lordships, that there
can be no latitude. That is some substance of your arguments. Yes.
Right. Two very quick responses, my lord. Two very quick responses, because certain points have been raised which do require response. First point was that under Chapter 8, Rule 10, may
or shall.
So my friend's request is that may should be read as giving a choice to them to take permission or not to take permission. Lordship, I have to express my surprise at that submission, because if that is the treatment to be given to Rule 10, where may appears to give a choice to the person concerned, then the entire chapter, wherever may is used, has to be read as giving a choice. So starting from the first line of the Chapter 1, Rule 1 itself, an election petition under section so-and-so of the RP Act may be presented duly verified. So I have a choice not to present it duly verified, as per my friend's interpretation. Lordship, that interpretation will lead to, with all respect, absurdity, my lord.
Yeah.
That choice is not available. May can be read as shall under certain circumstances, but it cannot cause violence to the provision. By reading may as giving an option, may will have to be read as shall in this Rule 10. It is mandatory. It is mandatory.
Yeah.
Because without, I still haven't finished. If I can finish my, let me finish.
Just conclude it. Yes.
I'll conclude.
What do you want to say?
So my first quick response is may does not give any choice. It is mandatory. It has to be read as shall. Number one. Number two, my lord. A lot of time was spent by my friend on threshold bar, whether 86(1) is the threshold bar, etc. Without spending too much more time on that, even assuming it to be true, that at the threshold itself, assuming but not conceding, my lord, that at the threshold itself under 86(1), Lordship, Honourable Court can dismiss my election petition. 86(1), the language is very clear, my lord. The language, 86(1), there is an absence of a description of the stage at which the dismissal can occur. 86(1) says that any petition that does not comply with section so-and-so and so-and-so can be dismissed or has to be dismissed. But at what stage? Yes. I would submit that at the final stage also, 86(1) can come into play. Okay. Simply because I have not presented it personally, even at the stage of final judgment, Lordship can invoke 86(1) and dismiss it. It doesn't, or it should not. It should not be raised or should not be framed as a preliminary issue. It can be invoked at any time. Second quick response. Third, very important response, my lord. And again, I have to express my surprise. My friend has referred to the judgment at page 26 of the compilation, of my compilation, which is a 2016 judgment, and claimed that also is a constitutional bench judgment which appears to have overridden or said something else other than the 1999 constitutional bench judgment, which I have relied on. My judgment, 1999, is a constitutional bench judgment.
2016?
Constitutional bench judgment, I'm certain my friend is aware, means a bench of 5 judges. 2016 is a bench of 3 judges. 2018, my lord, not 2016. Sorry.
Which one are you referring to?
So, 1999, where I've...
No. You're saying that it's a three-judge bench,
to-
2016,
at page 2018, my lord. I apologize. 2018 SCC.
Page?
26 of the compilation, which my friend had spent some time on.
Patel Mohammed.
Yes,
Patel Ahmed.
Yes, my lord.
Okay.
So,
That is?
3 judges, what little I know of the hierarchy of courts, 3 judges cannot override 5 judges, my lord.
Your Lordships, now if I may submit.
Lastly,
once again.
Lastly, my friend again had submitted that onus is on me to show, number one, I was present.
Yes. Yes.
According to her, my lord, lastly, onus is on me to show, number one, I was present. Number two, that Mrs. Lanong was the stamped reporter. I have to produce evidence. I agree. I have to produce evidence. And I will produce evidence, but not in a miscase, my lord. Not in a miscase. And Lordship had adopted that view, my lord, had adopted that approach in the earlier judgment, which my friend had also relied on.
Well, it's only the basis that it can't be conclusive, that is why.
Absolutely. Para 14.
It's a very serious matter.
Para 14
it
of...
can't be summary also, yes.
Absolutely, my lord, absolutely. That is the point, my lord. Para 14 of Lordship's earlier judgment, which my friend had relied on. Lordship had taken the view that this cannot be decided at this stage. These issues cannot be decided at this stage. And they can be taken up as a preliminary issue. 3 judgments were referred to by my friend. These are judgments which settle or reiterate general principles of law. I have no argument with these judgments.
2020,
2023, 2020, 2002.
Yes.
These are judgments which establish or settle or reiterate general principles of law. I have no argument against those judgments.
Yes.
That's all.
Your Lordships, I have my reply only to the section 86 being threshold bar. Your Lordships, I am relying on the judgment which has been filed by my learned friend only. And I inadvertently pointed out to be a constitution bench. It is duly a 3-judge bench judgment, Your Lordships, but still binding on this honourable court. And the relevant para, I have marked also, Your Lordships, that in that particular judgment also, Your Lordships, the Honourable Supreme Court has categorically held that if the applicant is in a position to establish that the copies are not true copy, which according to me is a material, which according to the court also, Your Lordships, is a material discrepancy to be decided by this honourable court. And if the applicant is is in a position to establish that the section that it is not a true copy, then it has to be, the petition is liable to be dismissed at the threshold only, Your Lordships, under section 86 clause 1, Your Lordships, and that very well follows from that very judgment only, Your Lordships.
Right. We'll pass orders. Yes.
Lordship, should we file bullet points just for assistance? I can file by tomorrow also.
Then you file bullet
Your Lordships,
points.
I will also file, Your Lordships, then.
By
after a week, file bullet points.
Very
Please, Your Lordships, I'm deeply
just
obliged.
after 1 week for filing bullet points.
Grateful, Your Lordships.
Item 11.
Sorry, Your Lordship, I could not come on time.
It's all right.
Your Lordship,
Yes. What
I
instructions
have
have you
received the instruction, but Your Lordship, it's purely a temporary arrangement for...
Temporary instructions you received?
No, not temporary, because his appointment is purely temporary.
Where's that?
It is...
You heard that?
No, Your Lordship, it is temporary because, Your Lordship, I will be filing shortly, because he never appeared before any examination or anything, and it is by the department. As per the instruction, your letter is, Your Lordship, one notification dated September 2015, Your Lordship. Kindly have a look, Your Lordship.
He's been terminated now, he's working 2001.
No, because, Your Lordship, there is no, it's a
That is one
project.
thing.
No,
Now,
Your
2001, a person been working, and then suddenly one fine morning.
No, Your
he
Lordship,
gets a termination
2007
order.
also, it is renewed for 29 day.
Even there are many judgments now.
But
You
no.
take it out.
Lordship,
MSB,
we have
where's the instruction?
Your Lordship, yes,
We have
File
filed one
affidavit,
representation
yes,
also, Your Lordship.
What letter you received?
because, Your Lordship,
Let us
that
see.
project is for only for a particular period, Your Lordship, and that project is, it is not under purely for the government, Your Lordship. You will look project.
It's a scheme.
Scheme, Your Lordship. It is a, scheme is no more there, Your Lordship.
This is
First page, Your Lordship.
2023.
This is 2023, but he has been working, but it is only...
But you've been shifting him here and there. He's multitasking. He was a typist.
This is purely, it is already written,
So
Your
you
Lordship,
extract the
temporary.
service from this poor fellow for around 23, 24 years. And one fine day, he becomes like that old horse. You have to put it out to seed or to grass and just, his appointment temporary, kick him out.
Your Lordship, I may be allowed to file my reply, Your Lordship, and only respondent number 3.
As Saji today submits instructions that the writ petitioner was never a regular employee
Not,
and was purely employed on a temporary basis.
Yes, Your
And
Lordship.
as such, the termination cannot be termed as illegal. She prays aloud. How much time?
2 weeks, Your Lordship.
2 weeks and a file affidavit.
Not only that, Your Lordship, one agreement was signed with the respondent number 3, who is not a pure government, project manager, Your Lordship.
Even then, see, something like
Yes,
the
I
quasi
understand
or the
here. Yes,
whatever,
sir.
if you work in a certain scheme,
Yes,
and
sir.
the scheme ends, we can understand. But if you appoint a person as a typist out to work in the office, then there's some Swachh Bharat thing that comes open, you put him there, so that kind of thing, this person now has been living 23, 24 years, it's an entire
Let me
service
come
life.
up with the affidavit in opposition, Your Lordship.
Otherwise,
Next time.
yes, you compensate him
6.
1 crore, then he can retire in peace. Yes.
Supplement, item number 6.
Yes.
Well, it's bizarre case.
What is this?
Bizarre case.
Well, it's the
Bizarre
petitioner.
case?
Bizarre,
Oh,
Malaj.
bizarre.
2006, Malaj, I was placed under suspension. At page 26, Malaj, I was placed under suspension in 2006.
2006.
Malaj,
Till now you're under suspension.
I am under suspension.
Getting subsistence allowance.
Nothing, Malaj.
Then?
I was asked to appear before the authorities, Malaj, on 4/10/2006 at page 27, Malaj, which I did.
What happened after that?
After that, nothing has happened, Malaj. Neither charges have been framed. Nothing has been done, Malaj.
Issue notice to the...
And Malaj, now what has happened, the immediate cause of action for coming to before your lordships is, Malaj, I was staying in the quarters of the college, Malaj. Now I've got a notice.
Where's that order?
Your lordships would find that at page 628, Malaj.
What has nothing to do with nothing to do with your suspension?
Well, that's the only place. I'm
New
not.
Education policy.
It's just been softly worded, Malaj, if I may just put it like that.
Within 3 months. This is 26/2. 3 months
He has
over.
come before the court now, Your Lordship.
3 months over now.
Almost.
Almost, not over yet.
Give him some protection, yes. Heard Mr. K.
I am only
Corners
for
in
the state
council.
respondents. The
Yes,
3, 4 and 5 is
issue
the
notice
college,
MS,
the institution which has...
Yangi, Leonard AAG with R. Koni present, except notice on behalf of respondents 1
1
and
and
2. So, a notice to issue to the other respondents within 3 days. Till the next date is where's that?
Well, it's a
vacation notice dated 26/2/2024.
24, Your Lordship.
Bracket next year 6 writ petition shall be kept in abeyance.
Yes. Obliged.
But how is it possible if you're sure that the inquiry never concluded?
He's a peon, Malaj. He's been going
He's an
there.
LDA now, as per your own petition.
But he been promoted during the suspension period.
As a Mali, no, as a Mali, he was promoted to LDA.
LDA.
Then during that period, there was some fraud in the
But
college.
that's 2006.
Yes,
Now
Your
it's
Lordship, in
2024.
2004.
Incident
2004,
of 2004, Malaj, suspended in 2006 till today, Malaj, is pending. There's nothing that's transpired after that.
then he was also quiet all these years, Your Lordship. Only after getting the vacation notice, he has come before the court.
Without any,
He must be having an alternate source of income, Your Lordship.
That is not for me to...
No, I mean, I'm just assuming. So let the college come and say that.
Hearing. Supplementary list 9.
Obliged.
Supplementary list 9.
what happened to Adalat?
The petitioner presented herself, Lordship, and the parties have assured that
Have come to settlement.
Your Lordship, I don't have any information, Your Lordship.
she was assured that they'll look into the matter and try to settle it, Lordship. But
Yes. Oh yes, it's settled. You've still not seen this award?
Lordship?
You've not seen the award of the Lok Adalat?
No, Lordship, I have not.
You have a look at it. We'll close it. She's accepted. She's willing to accept discharge with effect 1989. Let Mr. Pandey. So both of you examine it. So your client didn't inform you?
No, Lordship. Lordship.
That's always the case. Yes, seen the office note at flag A, stop the instant matter had been placed for Lok Adalat held on 11/5, 2024, and the matter has been since been settled between the parties. Copy of the award is made part of the order. Accordingly, the award dated 11/5/22 by Lok Adalat, matter stands closed and disposed.
Highly obliged, Lordship.
Obliged, Lordship.
Daily list, item 13.
Number one, Yes. Where were you this matter, Mr.
We have finished our submissions.
Authorities.
Authorities have already supplied today.
No, we have not got any authorities.
Yes, we have submitted last date. On the last occasion, we have submitted the authorities.
More authorities.
Most of them. He was supposed to supply this.
Lordship, I have some item instruction.
This matter where it was then kept in abeyance,
Yes.
again and again.
Several times it was kept in abeyance, and for 14 years they have been serving.
Yes, Mr. Shulai.
Lordship, I have an alternate submission, Your Lordship. My first view is that they don't have the right to be regularized. They are bound to be by the terms and condition of the advertisement, and also by the term and condition of the.
It's a very peculiar case. You can't apply
Lordship.
same formula.
But Lordship, in the alternative, Your Lordship, then if they are to be regularized, then they must undergo.
That is what this court last
Lordship,
time
yes.
had observed
Lordship,
last time,
yes.
that whether
Lordship, yes.
it's possible if you can have a special recruitment.
Lordship, in fact, Lordship,
exercise only for the petitioners.
In fact, Your Lordship, in the decision taken by the Cabinet in the matter of regularization, Your Lordship, that clause is there, Your Lordship.
Yes, because see,
Lordship,
the thing is that now you can't expect them to pass a regular exam, 14 years.
Lordship, can
you think you can write law exam now, Mr. Shulai?
Lordship.
Same thing. The new students have new ideas. Yes.
They have to undergo, Your Lordship.
Where is
they'll
that?
have to. Lordship, can you see that letter dated 23 June 22,
Yes.
Lordship? I'll read it, Your Lordship. In inviting reference to the subject, I am directed to see that following ad hoc under the department approved by the Cabinet for subject against sanction course for only subject to rule and apply prospectively from the date of use and the ad hoc by undergo the special examination interview conducted by the for the purpose of Meghalaya or the district.
Accept this
selection
proposal?
My problem is that the three of the colleagues of the petitioner, they were
They've been
called
regularized.
the same year, and we have been serving for 14 years. So what will happen to these 14 years which we have served, my lord?
It will take whatever is there.
So they will be much below the rank later on. So we are highly unjust
You have
for
taken
them.
all the juicy parts. You'll get only the remaining parts from that. Then what are you going to do?
They will be in a very difficult
be
position.
upset.
About 14 years they will lose in that case.
No, I don't
There
think,
is
Your
some
Lordship.
protection should be provided, my lord.
Lordship, for the
this
purpose
14
of.
years.
If protection, you want regularization from the date of the initial appointment, that will be.
Or from the date when their colleagues were called for interview.
When will they
for 1
regularize the
year.
colleagues?
Just within 1 year of the appointment, they were called separately. Three of them.
How did it happen?
Yes, like that. Arbitrarily, only 3 were selected. They were called for
Then
interview.
we'll ask for them to be prospectively now from the date when we will regularize. Return back all the extra payments they've made. we have that be positive equality. You're seeking negative equality because they've been just now. So how do we balance equities?
Some protection may be granted by your lordship.
But suppose you don't get selected in the special selection they have. And what will
That
happen?
is another issue, your lordship.
If you're found totally unfit.
That's a very risky proposition.
Very risky proposition. So anyway, you agree with this proposal? No more
Lordship,
parties?
yes. Lordship, yes.
Yes, then we'll pass order this.
Lordship.
Yes, we reserve judgment.
Apply. Lordship 13 to 23, your lordship.
24.
Apply, your lordship.
This is that matter, Millard, where the civil suit was filed, Millard, and subsequently an application for.
Yes.
So, Millard, in this, Millard, it was being considered whether the matter can be referred to arbitration straight from here, Millard. That, Millard, in my humble and respectful submission, Millard, that would amount to an appointment of an arbitrator by this Honourable High Court itself, which would not be strictly in accordance with the...
Does the arbitration clause exist?
Arbitration clause is there.
That's what they say, They file an application before a
Section 8.
For appointment of
Oh, Section 8. Section 8.
Section 8
says. Good for everything because this matter has been, it was heard once long time ago after that.
What happened is, the suit was filed somewhere.
The wrong court, right.
Wrong court, it was filed, Section 8, but the end result, what I had submitted before Lordships, the end effect of that Section 8 application was to appoint an arbitrator. Supposing that application got allowed, it would have tantamount to appointment of an arbitrator, and I suggested that your Lordships can, at this stage, also appoint an arbitrator and send refer the matter to arbitration, which we were aware of.
So you agreeable if we take this as an 11.6 application?
Sorry, Millard?
Section 8 and 11.6 are
Almost similar.
Of course, Millard.
11.6 for the High Court.
Because, the original scheme, as was under the agreement, provided for some person in-house arbitrator. Now, that has been done away under the 2006 amendment. So, it has to be, ultimately, it would have to be...
You agreed on arbitrator, then we will dispose of the matter and then...
I had suggested some names.
Millard, I have tried to get instructions on that. Millard.
No, somebody, suggest a panel, a panel, whatever. Then we cut short this whole matter instead of dragging it here and there. Because you said you agreed with the only thing is with the cost inflicted, right? Which you have not paid the cost.
No.
But here the only aspect is that, Millard, here under the arbitration clause, the power to appoint the arbitrator is retained by my client.
Yes.
That is the thing, Millard. So if they be given the discretion, because it's a company, Millard, they have to sit in a board.
That has been done away under the new scheme.
You suggest the names.
That's the law, the original scheme of appointing in-house arbitrators by one party has been done away with.
Millard, that aspect...
We will appoint, you just give a list of names. We will just cut the whole thing short. Give a list of names which you feel are suitable. I mean, then you pick out one out.
Millard, this has been pending on this point for quite some time.
Really?
And I have tried my
then the court will appoint.
I have tried my best. But I would humbly submit that the impugned judgment, whereby some costs have been imposed, Millard, and also the factual...
That will address that. I think Mr. Paul won't have an issue with that also.
But if that is addressed...
I am as a matter of fact conceding that let it go in for arbitration.
Yes.
So, Millard, if that is considered, Millard...
I'll just give you one last opportunity. Please come, because the court doesn't want to... we can appoint, but then, otherwise we'll appoint...
Your Lordship had even given an observation in your Lordship's order earlier. And that was communicated also earlier, Millard. Still nothing has come out of it. So, Millard, I would submit, Millard, that...
Pass orders.
Millard, if the matter is sent back to the court and setting aside that order, Millard.
That even I'll have to argue.
Then we'll have to argue because...
There may be it may be considered on that. It may come up after some time, maybe.
We'll give you 2 weeks' time.
It may come up after the 10th, 10th of June.
Why you leave these long vacations, Mrs. Florty?
Under some personal commitments.
The last time, after 15th, after 10th May, now
it
after
is being,
10th June.
the thing is going on and on. Now I'm sure before the 10th of June, it will be done.
No objection.
Yes.
After the 10th of June.
Learned counsel for the senior counsel for the petitioner submits that the matter may be placed after 10 June to enable them to come forward with instructions with regard to appointment arbitrator. Yes. It is also observed herein that as the matter has been long pending, and to avoid any further delay, it would perhaps be expedient if the matter is referred to arbitration.
Well, Lordship may grant us the liberty. I'll file a list, my lords, and along with the advance copy to them.
Parties are liberty also to furnish a panel a list of names.
So
yes.
only if that be the case, then that arbitration clause is being circumvented. That is that aspect, Your Lordship, whether Your Lordships would do that.
Okay, forget that part.
If we decide on an arbitrator and come before Your Lordship, then oblige.
The Lordship will kindly observe, my lords, that parties would be at liberty to seek instructions whether they would be willing to proceed for arbitration from here. Then it would make everybody's life easier.
As long has been matter along delayed, the parties are liberty to, to explore the possibility of the matter being settled as per the arbitration clause in the contract.
Malik.
26. 26.
May I please, Your Lordship, we have received instruction.
This is the hearing stage, MS
Yes,
Pasar.
Your Lordship, ISCO directed that we just want documents to bring on record, Your Lordship. So
What document?
From the auditor and Central Auditor General, Your Lordship. So we'll file a small file.
Is Mr. Siddiqui privy to this document? What document? Let the court have a look.
This is already on record, my lord. This is the imping order, my lord.
It's already there in the petition.
Yes. The imping order which we receive, it also says, however, as there is an earning member of the family and your family is entitled to receive family pension at the enhanced rate till 24, and there are no liabilities in the family, the company note 13 headquarter office has not accorded approval for a reappointment on compensatory ground. Same thing is also, this also contains the same thing.
Same thing, Your Lordship, but this one, it's dated, the date is different, Your Lordship, it's 2018.
Okay, bring on record. MS Pasar raised you allowed to bring on record a letter dated 8/1/2018, wherein the reasons have been detailed therein for refusal of the respondents to provide family pension to the or compassionate appointment to the petitioner. Yes, we'll take this copy on board. Yes, just keep it here. We'll not record it. Yes, just up to 2 weeks. Yes. Then the court will pass the orders as.
Yes, my lord, on that basis.
27.
It's for hearing, my lord.
Yes, it's for hearing. The hearing is correct.
Yes, my lord.
You ready?
You're ready, my lord. The parties also, they're here.
Who are the parties?
We have 3 respondents, my lord.
Regarding that house by the river?
Yes, my lord.
Yes.
Ready? Then we shall do it.
Now, a pollution control board?
There's no pollution.
Under who stopped your construction?
The district magistrate, my lord.
Or district magistrate?
Yes.
Mr. Moment appearing for whom?
Headman.
Headman? Headman is objecting?
No, I've issued no NOC.
And objecting also?
Your Lordship, they issued a land holding certificate.
We only issued a land holding certificate, and when the construction
Then why do you issue land holding now when you made construction violation of the NGT norms?
We only issued a land holding certificate, and so far as the construction is concerned, there was no permission sought from the district council. So we were not aware that they have constructed any house.
It is not required, my lord. The land holding certificate was issued prior to the order.
Who's the
passed by
authority
the
to grant you permission to make houses there? That
The
joint
Dorpash,
municipal
no,
board?
my lord. It is a usual practice, your lordship also.
Aloy,
No, no, my lord.
have you got permission from town committee?
No, my lord.
There's a law to that effect.
It's a usual practice.
Okay, just let's hear Mr. Shangwan first. Yes.
If I may start from the beginning.
Please start from the beginning. Yes.
May I
The
please, your
genesis
lordship?
of the case.
Yes, my lord. I'll just brief the facts of the case, my lord. And by way of this petition, my lord, we are challenging the impugned order dated 16/8/2022, which is at annexure 7, page 29, my lord, of the writ petition. Now, this is the eviction notice issued by respondent number 3, who is a district magistrate.
Which page?
Page 29, annexure 7.
Yes.
If I may read, your lordship, this is the eviction notice.
This is issued by the
Magistrate.
district magistrate, who's represented by MS Lingwa.
Yes, my lord.
The eviction notice.
Eviction notice. Now, whereas a letter has been served on you to number so-and-so, dated 5th July 2022, requiring you to show cause regarding the construction of your house within 50 meters from the Mintudu River, whereas your reply on the matter is insufficient and that you have not offered any valid reason for violation of the order. Now, therefore, in compliance of the order of the Honorable National Green Tribunal in OA number so-and-so, dated 16/7/2022, you are directed to vacate the premises of the said building within 15 days from the date of issue of this notice. Take notice that your house and the structure standing within 50 meters from Mintudu River shall be dismantled after the expiry of 15
Now
days.
this house, are you staying in it?
Yes, my lord. I'm residing therein.
You got water connection and PHE also?
Electricity connection also is there.
And water connection?
Water connection, I have to take instruction. I don't know, my lord.
You're close to the river, so you don't need water connection. No.
It's not that.
Okay, yes.
Then the brief fact, the case, my lord, is before prior of this eviction notice.
This is dated 16 August, correct?
16 August. If I may please first the chronological order of
1
the
second, just,
facts, my lord.
okay. 16/8.
16/8/2022.
This is the main.
This is the main.
Okay. Yes.
And a brief fact, the case, my lord, is that the petitioner herein, they have acquired the plot of land known as Banshatingit, situated at Klet Tershi village, by an outright purchase from on 1/3/2016 at a consideration
1 second,
price.
just stop there. Now, does this have any bearing with the division bench exercise with regard to construction near water bodies and rivers?
As of now, my lord, policy has been
Has any
framed.
policy been framed?
No, no policy. If the state government can reply, if there's a policy.
Who appeared in the case?
So there's a recent order passed. So far as the guidelines are being framed.
What do the guidelines say?
50 meters.
And their house? Their house?
It's within 15 meters, Your Lordship.
Is beyond 50
That
meters?
they have stated that it is within 50 meters.
So who'll go and
But
measure
they
it?
have filed this affidavit. They have never brought on record.
No,
that
that's the
record
only
also.
thing. If it's within 50 meters, then notwithstanding any NGT orders, also we can give you some
No, my lord.
latitude.
They have stated that my house is within 50 meters. When did they conduct the spot inspection? That also is not bring forward by the respondents here.
They'll send Mr. Sinkon to go and measure it tomorrow.
They have never called me for that spot inspection. If I may take your lordship, then before going to the case, if I may take your lordship to this NGT order, which they have placed. If your
Now,
lordship have
that
it.
order says, this eviction is this, where have they said that violation of NGT order?
They have mentioned
the
that
only thing is they say that compliance of order.
Yes, compliance of
You're
order.
directed to vacate. Now, you understand 50 meters. They have not furnished you any inquiry report or any
No, my lord.
findings.
No findings, no report. Prior to this, they have issued one show cause notice, which is dated 5th July 2022, annexure 5, my lord, page 23.
That's all right. I mean,
But on reading the judgments passed by the National
NGT.
Green Tribunal, there's nowhere mentioned of
Where
50
we have the
meters.
judgment here. What does it say?
We have the judgment. If I may take your lordship first to the judgment dated 27 February 2017. What is the petitioner's aggrieved here? I'll take your lordship to page number 2. Your lordship is there as the bottom paragraph. Upon perusal of the OA, we find that serious issues have been raised pertaining to the health of the river, Mintadu in the Giant Hills. My lordship is there.
You stated the color of the river has been turned blue.
Yes, yes. It is stated that the color of the river has turned blue because of the high acid content, and as per reports prepared by State Pollution Control Board in the year 2012. It is alleged that there are rampant encroachments. Now, there are 4 issues here which the NGT had dealt in by this order. One is a rampant encroachment, the river being degraded by human intervention and reduced in size on account of heavy situation. Further allegation is that the people indulge in open defecation. That is the second issue. Open defecation, as a result of which the fecal coliform and the total coliform counts are very high, and the BOD, that is a biochemical oxygen demand level, is beyond the permissible limit. This apart, there is also allegation of illegal stone and sand mining. That is a third issue which they have dealt here, being carried on around the river. The other allegations are: 1, disposal of untreated wastewater and seepage of acidic contents of coal.
In Minturu River, acidic contents?
Acidic contents.
In Minturu River?
Minturu River.
There is coal mining around the site.
No, I don't know, but this is the order which has been reflected, my lord, which they have raised before the National
Maybe
Green
because only, I think, to personal knowledge, Mintang River doesn't have any mining anywhere in Mintang. Correct?
But I think they have stored, there are some coal piles up near the
Mintang
River, which the acidic water is going onto the river. Okay. So these are the only 4 issues which they have dealt with in this order.
Yes.
Mainly, my lord, it deals with the rampant encroachment, open defecation, illegal stone sand mining, and the disposal of untreated. The direction says, in the meantime, we direct the state respondents to ensure that no illegal sand mining and other such activities are permitted along the river bank. Action taken report on this shall also be filed before the next day. If I may take your lordship to the second order, which is the final order passed by the National Green Tribunal, that is, date of hearing is on 18/7/2022.
Yes.
I'll just highlight the important points, my lord. The first, Order 1, Paragraph 1, my lord, filed on 30/11/2016. It first came up for hearing before the Eastern Zone Bench so-and-so dated when notice was issued to the respondent from the river, but direction has been issued to ensure ban on mining. CPCB has stated that the authorities in state have to take remedial action as follows. A, untreated wastewater should not be discharged into the river system. B, sewage collection should be done through a proper conveyance system so that the entire sewage is collected and treated. C, page number 3, my lord, a sewage treatment plant shall be equipped with DG set, which can be used in case of power failure to ensure that the treatment is not interrupted. D, suitable treatment shall be given so that treated effluent meets the prescribed standards as notified in the General Standards for Discharge of Environmental Pollutants into inland surface, public sewers, lands for irrigation, marine coastal areas under Schedule 6 of the Environment Protection Rules 1986. E, biomedical rules should be implemented for prevention of discharge of hospital-related waste into the river system. F, to prevent illegal encroachment, all stakeholders agencies make mechanism. G, guidelines issued on idle immersions must be implemented by SPCBs and local authorities. H, mass awareness programs should be organized to make the mass awareness on maintaining the quality of the river water. Now, paragraph 4, my lord. The Jowai Municipal Board has stated that it has practically no source of income to remedy the situation. Its garbage dumping grounds has already reached saturation point. Waste management treatment plan to be funded by the central government is to be set up, for which the DPR was prepared. Similarly, CETP is to be set up. The board has issued order under Section 144 CRPC prohibiting dumping of waste in the river. Directions have also been issued to stop car washing. The Autonomous District Council have also been asked to take measures to protect the river. Paragraph number 5, the state of Meghalaya in its reply has acknowledged that the waste is being dumped into the river and illegal mining is being conducted. The urban planning is poor and hygienic conditions are not ensured. There are rampant unauthorized constructions. Industries have been set up close to the river bed as there is no policy of the state on the subject. I'll stop there, Your Lordship. I'll take Your Lordship to page number 4, which is paragraph number 10. According to the learned counsel for the applicant, there is not much improvement in the ground situation. Pollution of the river is still taking place by dumping of waste and muck during road construction. Illegal mining and encroachments are also continuing. Now, let me take to page 5, paragraph number 12. The result of water sample analysis filed by the CPCB and the state PCB indicated that the tributaries of Mintudu River are highly polluted in terms of BOD and fecal coliform and total coliform. However, there is no clear gap analysis as sewage and solid waste management, nor a clear roadmap to control discharge of effluents, including acidic effluents, regulations of mining activities, and removal of encroachment in the catchment and the floodplain zone of the river. Now, page 6, there are the proposed remedial action to be taken by the state. I may take Your Lordship to page number 7, serial number 6.
Yes.
Encroachment in the catchment and floodplain zone, and
from?
there, that is page number 7.
The table.
Table, my lord. Serial number 6.
Yes.
Encroachment in catchment and floodplain zone and their removal. Show cause notices to encroachers have been issued. All encroachers are to be removed in accordance with law. Now, if I may stop here, my lord, for the time being. They have termed me as an encroacher, my lord. But what is the definition of an encroacher, my lord? I want to place it before Your Lordship.
You're a legal encroacher.
I'm a legal encroacher.
Not an illegal encroacher.
Not illegal encroacher, my lord.
But you see you're an encroacher all the way.
Yes.
Yes?
No, my lord. If they term me as an encroacher, that means I do not have any right title to possess that land. But it is an admitted fact that I've purchased that land by an outright purchase from one
One
person.
thing was to just show that how this order will apply to you. And so the basis the entire notice goes.
Yes.
Yes.
In my humble submission, this case is not relevant at all because first, on the first point, my lord, I am not an illegal encroacher. And the second point, my lord, which I want to stress
Now, one
here.
thing, are the other people civilly situated when issued notices?
Yes, they are there.
They are there also.
They are there.
But they have not come to court.
They have never come
They are the people who have built houses there only.
Yes.
They're all like legal occupants of the land.
I
of certain
think so, my
settlers.
lord. Assuming they are, my lord. Because they have never come forward, so we're not aware of that. And the first thing, this eviction notice, my lord, is not tenable and it's not legally sustainable.
No, now, what happened now? Is there stay orders operating?
Stay order is there.
Regard the other houses, any steps have been taken to remove them?
No.
But they're all
residing.
situated than yours or better?
They are
all on the same line.
They are in the same line.
Now, how do you approach how there's a road going?
There is a road from the top of the...
I mean, there's no road going by a house.
Yes.
You have to go on foot.
On foot. And then between my house and the river bank of Mintudu, there is also one motorable road in the middle. It's not like close to the river itself. And I want to stress...
You attached photographs, didn't attach photographs of your house?
No, my lord, I did not attach the photograph. But first, on the one ground itself, my lord, this legal notice, which eviction notice, is not legally sustainable. Why I'm saying so, my lord? The district magistrate here has exercised power beyond its jurisdiction, which it has no authority to issue the eviction notice. That is number one point. Based on that ground itself, my lord, this eviction notice should be set aside and quashed. Why I'm saying so, my lord? If I may take your lordship to the affidavit filed by the state respondents.
So from your petition, that's all. That doesn't cover you because it only says encroachments,
Yes,
catchment of flood plain, right?
Yes, my lord.
So you're not, but yeah, okay.
Now, with regard to the validity of this eviction notice, my lord, if I may take your lordship to page number 3 of the affidavit and opposition filed by the state respondents.
Filed on?
April 2023, my lord.
Filed by which respondent? State respondents?
Respondents number 3, yes, my lord. State respondents, my lord.
Which page you want to show?
Page number 3, paragraph number 7, my lord.
That with regard to women's.
Yes, my lord. But the point which I want to stress here to show the illegality of the eviction notice that is not legally sustainable, my lord, is at the page number 3. If I may read from line number 5, my lord, which says that according to the NGT order, no construction of any structure, whether permanent or temporary, for residential or commercial or industrial or any other purposes, shall be undertaken within 50 meters of the bank of any river, which they have made up, interpret the order of the NGT. In addition to the above, it is further stated that as per notified 10/11/2020 issued by the Office of the Giant Hills Autonomous District Council, Joai, meetings were held on 31/5/2017 and 12/10/2017, which was convened by the Deputy Commissioner, West Giant Hills District, whereby it was resolved that the Giant Hills Autonomous District Council, which is the competent authority for the management and control of rivers in the Giant Hills Autonomous Districts, and also the sole authority recognized for issuing of land documents such as Pata and Settlement Certificate, land holding certificate, shall specify the minimum distance from the river required to be kept clear and free from any kind of construction.
That,
my lord?
They identified the amount that the land hold certificate specifies that?
No.
No.
It was before the NGT order. What I want to show here, my lord, here they have admitted that they do not have the authority to issue any notification which falls under the scheduled areas.
See, whatever it is, but since order of NGT exists, it's incumbent upon the authorities also, whether it's Pollution Control Board, whatever, to see wherever there is some infringement.
My lord, but in this paragraph, they have pleaded that it's not beyond their authority. Now, when it comes to eviction notice, they have issued it. My humble submission is that if the eviction notice ought to have been issued, it should have been from the district council, not from the state government. The state government has only a role to play in the assistance of the law and order situation while discharging the notification passed by the district council.
What role does Mr. Momin play then?
Mr. Momin has issued me the no objection certificate for construction of the house, my lord.
Okay.
Which they are also supporting my case, because this notification which the district council has claimed that they have notified it has never been publicized, my lord. Even the Darbar Snong also does not have the knowledge about this notification. When I started the construction of the house also, my lord, in September 2020, till the completion of the house, like I've stated earlier, the construction of the house cannot be hidden from the world, but yet nobody has come forward to object me. Not even the district council, not even the district administration. Only when I have went to recite to the house, that is in the month of June, which they have issued me that show cause notice to show cause why I have
personal angle involved here also?
No personal angle, but as such, maybe because of the...
How big is the house? Very big.
I have constructed the house by way of a loan. It's not that big also. I'm still repaying that loan amount a lot.
Yes.
That is the third point which I want to raise, that notification has never been publicized.
Yes. Have you written that in your petition?
Yes, my lord. I was not aware of it. Even the Darbar Snong also was not aware of it. Hence, the no objection certificate was issued on my behalf to construct the house.
So first you say NGT has no application to your case because it involves, it's to do encroachers.
Encroachers, sand mining, illegal mining of sands and all.
No, you're fine. I mean, regarding construction, you're not encroacher, okay. And next is that the Deputy Commissioner
does not have the authority.
Has no jurisdiction because in the own affidavit said that the District Council competent authority to issue land holding certificates.
To issue notification for anyone to construct the house, it should be with after 15 meters beyond.
Permission granted by District Council?
Paramila?
No, like Shillong, no.
No.
Now in other areas? Okay. Then suppose you build a house in Juwai, who gives you permission? In normal circumstances?
Normal circumstances, my lord, that is a practice usually before the building bylaws came into picture.
From the headman?
From the headman itself.
Even inside Juwai proper?
That is in the Juwai, if you can answer.
As far as towns are concerned, it's regulated by an act.
But this does not fall in the town.
What act?
This is the Gentiles Autonomous District Village and Town Administration Act, 1974.
You don't cover their land?
We'll cover their land.
Then you didn't seek permission under that?
No application
There's a process for granting permission.
There are rules also.
Then?
No, my lord.
We didn't receive any application yet.
You didn't take any action also. You don't have,
They
do you
have
take action,
never-
suppose you see illegal or construction, do you ask them whether you receive permission or not?
So far as this matter is concerned, after the executive orders was passed, there was a meeting with the Deputy Commissioner. Based on that meeting, we issued a notification. Now that notification was much prior to the issuance of landholding certificate. And so far as the construction of the house by the petitioner, that was not made aware. We are not known to that.
So houses are generally constructed, do they come before the council to seek permission? In normal course, it's just there's no rule of law. They just keep on constructing.
The act is in place, but how far is the act enforced?
That is not the usual practice also, my lord. My friend has insisted that it falls on the town, but in my humble submission, in my knowledge, which I've get the instruction, that it does not fall under the town committee of the district council. It is in the rural areas, my lord.
You said on Mintru. Which part of Mintru? Near Jowai or beyond?
It falls under
the sea is just near the bridge, it means.
The sea jurisdiction is after the bridge.
So that the basis of the entire objection is only that your house 50 meters near the river.
Yes.
You say it's not.
They say that that is.
By your own estimate, how far is the house from the river?
That we cannot see, my lord, until it is measured properly.
But does the council remove other encroachments?
No.
On their own?
And they have never cancelled the land holding certificate also, my lord.
But you won't cancel land holding can be land.
Yes.
But doesn't mean that you can't own land, but then building is different thing. Having a land holding certificate and owning land is one part, but building is another part. See, you might have land here. Now you want to build a house. Suppose you see within the urban limits, you have to take from Muda. You have to take permission.
Yes.
Doesn't mean that you having a patta doesn't mean that you can construct anything you want. But whether that's a thing, it cuts both ways also. Land holding will not, it just gives you a right of occupation that yes, you have that. But building something else. Building bylaws are there everywhere. Why is the Town Country Planning Act? Why is the building bylaws? Courts want to know whether you start a construction on the basis of any tangible kind of permission given by some authority. That's why this roving inquiry. Yes. Now, the thing is that Mr. Nongpil said that there's been no permission. The only thing you've done is issued the landholding certificate. That's fine. That doesn't show you encroacher. Just shows you are owning some land. But whether your structure is in violation of the NGT norm, that is what we're trying to find. That's all.
Oh, the landholding certificate shows that this is a building site. It's written there in the landholding certificate. And so far as the
building site can be building site, but the thing is that whether that building been made as per norms, that's the only thing.
May I please, Your Lordship?
Yes.
Your Lordship, first of all, Your Lordship, we're not disputing the fact that the land belongs to the petitioner, Your Lordship. Now, throughout their petition, Your Lordship, if you see, Your Lordship, they said that they had applied for a housing loan, trying to mislead the court, Your Lordship. Now, because if you take a housing loan from any nationalized bank, Your Lordship, you
ask for land papers.
Yes, Your Lordship, you have to register and you get clearance from the government, like non-encumbrance certificate, land valuation.
Yes.
So when after I've pointed out that in my affidavit in opposition, they said that they had taken a personal loan. Now they've taken a personal loan. What they do with that personal loan, it's
up to them.
Yes, it's up to them. Your
It's not a house building loan.
Yes, Your Lordship. So we did not know that they were constructing, and the eviction notice did not go only to them, but there are many other households also.
You see, the thing is that we don't want this court to pass any order that comes like a sort of a license or permission to other encroachers. You see, that's the thing. That okay, fine, one has been got away. Okay, fine, might be an entirely a premise that is not really correct in law. And so we say, okay, fine, we quash that eviction notice. The DC had no power. Now we look at larger interest. Now the thing is that suppose that then the authorities will wash off their hands, sit back, then you'll find, squatters right at the bank of Mintru River, then what happened?
No, it will vary from case to case, my lord. That is a different thing.
No, but if they're not even willing to take up the case in a proper manner, and people should not be allowed to take advantage of that's what you see, rule of law should be there. As citizens, we are bound to, should abide without anyone telling us what to do.
Yes,
things like that.
I understand, Lord.
And Your Lordship, in pursuance to the NGT order, 2 meetings were held, Your Lordship. meeting dated 31/5/2017 and 12/10/2017. And in this meeting, Your Lordship, after this meeting, JHADC had issued this notification 10 November 2020 where the limits were set to 50 meters because,
With regard to
because it is within the jurisdiction of JHADC, Your Lordship.
But they never took any action. They never took any action.
Because we are not aware that this construction.
There's no inspection going on. No
And-
staff, no salary.
It can be seen from.
And Your Lordship, even the Shnong was present in those meetings. The Shnong, they were very well aware, Your Lordship, of this NGT order. Despite of that, Your Lordship, they issued them an NOC to construct.
Do physical verification. That's 50 meters
Yes,
around.
Your Lordship. There can be re-inspection, Your Lordship.
We can go for re-inspection,
Yes,
my
Your
lord.
Because you only have to establish that that notice was based on some solid information. That's the only thing. How did they come to the finding that's within 50 meters? They
That-
measured.
they'll have to
Yes, Your Lordship, there was a spot inspection.
They have
Your
never
Lordship.
produced that report. I was never
There was
called
a
for
spot
when the inspection
but
was conducted.
However, Your Lordship, we can go for a re-inspection also, Your Lordship.
And Joy is also washing their hands of the entire matter, like they've done in Umiam everywhere. Themselves building house on the water.
And even the Shnong, Your Lordship, they were very well
I'm talking
aware of
Khasil's
this
council.
order,
They build a house on the water themselves when it's supposed to be custodian of water bodies is. Yes. See, what about para 9 of your affidavit?
Yes, Your Lordship, there was a spot inspection, Your Lordship.
Now she's seen the show cause reply that was within 50 meters.
Show cause we have replied.
So
We
you
have
said within 50 meters.
No, my lord. If I may take your lordship to the show cause, which we have replied to the show cause notice.
Because it'll have wide implications. That's the only thing. Only concern this court.
Yes, my lord.
You want headlines tomorrow in the paper that
No, we understand, my
High
lord.
Court condones the house within 50 meters. What about the High Court? I mean the division bench. Sorry,
I'm
guidelines.
not there, Your Lordship, in that matter.
You're aware of it. You've notified. Let them check, Mr. Chongwan. Let us adjourn it for today. Let us take a larger picture, because your rights also have to be protected.
Yes, my lord.
And also the rights of citizens of this country, of the state. You bring the guidelines. The issue in question is with regard to the construction of the petitioner's house, which as per the eviction notice, which as per the impugned eviction notice is stated to be within 50 meters from the river, and as such in violation of the orders of the National Green Tribunal. However, as if there has been some, deliberations before the division bench of this court with regard to construction near water bodies, Mr. El Mangpur has volunteered to bring the required materials for this court. Yes, as to whether it has any bearing. Just after 2 weeks, yes.
Obliged, my lord.
So then we can incorporate that guidelines also into maybe give you some relief also.
28.
My lord.
Yes.
28.
Which time? I don't know. Where's Dr. Mozika?
Lordship, I'm praying for some accommodation on his behalf, Lordship.
He's not in court today.
He's there, Lordship.
Sorry, I saw him in the morning. When Mr. Pandey?
Lordship, this matter can come up after 1 week, Lordship. But before that, Lordship, I just pray that I may be allowed one submission, Lordship. If Lordship, I want to show you one letter, Lordship. Lordship has already observed based on that letter. That clears the whole picture, Lordship.
Which letter?
Affidavit in opposition filed by the respondent, Lordship. Page number 53, Lordship. The entire premise of the respondents to reject the pension, Lordship, is the 60%
Oh,
cut
yes,
of
yes,
that.
yes, yes.
Lordship. The first,
They were asked to take instructions on that also.
Lordship, yes. And Lordship, Lordship has that later, Lordship.
Yes.
The Lordship, para number 2 talks about there was never a 60% cut-off, Lordship, for disability pension, Lordship.
Number 4, you see.
Lordship, number 4, Lordship. In view of the above, Director General Assam Rifles is advised that the government servants who were boarded out before 15/2/2011 with less than 60% disability are also eligible for disability pension based on broad banding introduced with effect from 01/01/1996. Wide OM these Lordship. So this clears the whole picture, Lordship. So the entire basis of rejection, Lordship, goes, Lordship.
Then we'll dispose next date. After 1 week, yes.
Highly obliged, Lordship.
31. 31.
And for the respondent.
But other filaments appearing, Nambari. Some Nambari appear, not this one. It's connected to the other matter.
My lord, in fact, these matters are not maintainable, my lord.
Very difficult, Mr. Bora, to do, because even the courts are very difficult. In the other cases also, what he does is beyond the,
In fact, my lord, the decree was passed in the year 2015, and execution is already completed, my lord. And they had alternative remedy, my lord. They did not avail. And then
Didn't go for appeal also. Never appeal in
Never,
judgment
my
decree. Let him be there. You won't dismiss it just like that. Just after 2 weeks.
Let it come up together along with the other matter, my lord.
Item number 2.
When's coming?
2 weeks, sir. 2 weeks. Admission hearing.
Obliged.
35.
You have affected personal service?
Yes, Your Lordship, we have.
Yeah, but have they received? Where's that proof?
We have submitted the notice
When?
on 9/5/24
Somebody to whom?
to the respondent number 5, Your
So
Lordship.
you have to bring that on record. They have accepted notice.
Yes, Your Lordship, they
Let's
have
see the
accepted.
notice. What have you written there? Who's Lachit Hing? Secretary School Management Committee, Melapara. Who's the person who received the notice?
I have no instruction, Your Lordship. I have no instruction, Your
Then
Lordship.
who's the? See, it has to be. Should be on behalf of management committee. Now
Yes, Your
someone
Lordship.
signed it. Now someone just signed it. Some beyond the road. Someone signed it. Somebody. How do you know it's the person who's connected to the management committee? You know the names of the president.
I don't know, Your Lordship.
You get instructions. Though Ms. So-and-so has produced a notice indicating that the person has been served, does not indicate whether the person is the president or any functionary of the management committee of the respondent school. Petitioner to verify and file affidavit. We verify who's this person, Lachit. Lachit, what is this? Just after you get instructions after 2 weeks.
Okay, Your Lordship.
Yes.